Good morning, everyone. I hope you all had a good night's sleep. So welcome to our session on unlocking innovation through IP collateralization, which I am very honored to moderate. As I mentioned in my presentation yesterday, in APEC, we have worked over the past couple of years on a proposed reform strategy to enable the wider use of IP by innovative enterprises to access finance. And as I also mentioned, this is an initiative that has been steadily gaining support in APEC, and governments like Hong Kong, as we've heard yesterday, are expressing concrete interest in initiating regulatory sandboxes. Be that as it may, the way forward is not that simple, as is usually the case when we try to develop a new market. In order to achieve sufficient market depth, we still need to overcome quite a lot of things. And basically, that is a negative feedback loop around limited use of IP-based assets, which limits incentives for policymakers to act, and that in turn inhibits incentives for the market to develop these products. So our task for this session is to discuss approaches to legal frameworks and international coordination that can help us unlock the potential of IP assets as collateral. And for this task, we have assembled, as we always do, a rockstar panel, which is composed of Mr. Ivor Istuk, Senior Financial Sector Specialist in the World Bank's Finance, Competitiveness, and Innovation Global Practice. Ivor is joining us online. Mr. Doh-Uk Shin, Director for International Legal Policy at the Ministry of Justice of the Republic of Korea. Mr. Thomas Tsang, Deputy Director of IP of the Government of Hong Kong, SAR, and Mr. Johnson Kong, Board Member of the International IP Commercialization Council, and also the moving force behind our APFF IP Finance Initiative in ABAC and APEC. So we have an hour for this session, which I suggest to divide into 10-minute presentations by each of our panelists, followed hopefully by 10 minutes of Q&A and open discussions, and then we'll have a 5-minute summary and closing. So let me encourage our panelists to speak for a maximum of 10 minutes, less if possible, so we can have sufficient time for an interactive Q&A. And so without further ado, let me give the floor to our first speaker. Is Ivor online? No? Okay, so in that case, let me ask Doh-Uk Shin, who is here with us, to make his presentation. So, Mr. Shin, you have the floor.
Okay, thank you, Mr. Parreñas. Good morning, everyone. Honorable colleagues, I'm Doh-Uk Shin, the Director of the International Legal Policy Division at the Ministry of Justice of Republic of Korea. I deeply show my appreciation to your invitation to this valuable event. And it's my great honor to address this topic, the current status and future of Korea's IP-backed transaction. The International Legal Policy Division is responsible for developing international norms and incorporating them to Korea's domestic legal system. This includes aligning Korea's legislation with international standards such as the UNCITRAL model law on secure transaction. And we have been working to ensure that Korea's legal framework on intellectual property security reflect these norms. Today, I will give my presentation in 3 parts. First, the current status of IP financing in Korea. Second, the reason why IP financing has not yet reached its full potential. And third, our vision for future development. Korea has achieved a global success with intellectual property such as K-pop and K-drama. Yet, Korea's financial market that use IP as a collateral remains in its early stage. Most IP financing is concentrated on patents. Financing mechanism for copyright, trademark, and other forms of IP remains underdeveloped. Patent financing has grown rapidly. The total amount exceeding 10 trillion Korean won, roughly $8 billion as of August 2024. This growth was possible because patents operate under registration-based system, which provide clear scope of rights and a reliable, valuable valuation system compared to other form of IP. This made patents more suitable as a collateral asset. Such growth in patent financing can be also attributed to government-led legal and policy measures. Let me begin with the legal aspect. Patent Act Article 85 provides a statutory basis for using patents as collateral. Additionally, Article 45 permits technically related patents to be grouped into a single security portfolio. This grouping enhances patents' collateral value and its feasibility as collateral. Next, from a policy perspective, the Korean government has implemented several support mechanisms. First, technology credit evaluation system enables credible valuation results to be applied to directly in financial transactions. Second, the government covers part of patent valuation cost. Third, through its IP collateral recovery supporting system, the government reduced bank recovery risk by purchasing defaulted IP collateral. However, this support mechanism remained insufficient for intellectual property other than patent like copyright. I will explain this further in this moment. Copyrights are core asset to Korea content industry, yet two main barriers continue to prevent copyright from being used effectively in financing. Inadequate evaluation infrastructure. Although intangible asset can be hold great value, Korea currently valuation infrastructure is not developed enough to support financial and investment use. Many financial institutes lacks internal expertise needs to access IP. As a result, financial institutions rely heavily on public sector valuation. However, Korea does not yet have a credible valuation framework for copyright. This absence of framework creates legal and financial uncertainties. Financial institutions remain hesitant to issue loans. For copyright, institutions such as Korea Copyright Commission and Korea Creative Content Agency are conducting valuations. However, the institutions differ in their valuation criteria and method. These inconsistencies make a conducted valuation less reliable for the market. The other barrier is the recovery risk associated with IP collateral. Financial institutions view intellectual property as having higher value on stability and greater default risk than tangible assets. To overcome these barriers, Korea needs a well-developed IP training and liquidation market. But Korea does not yet have such IP market. This makes financial institutions reluctant to lend without additional debt recovery concern. For our path forward, advancing Korean IP financing market requires efforts in 5 key areas as follows. First, to broaden the scope of IP financing beyond patents, finance-friendly valuation model must be developed. The Framework Act on a Promotion of Cultural Industry Article 16-2 and 16-3 already allows the government to designate valuation institution and subsidize valuation cost. Building on this legal framework, we need a specialized valuation model tailored to different purposes, such as collateral, investment, or damage assessment. For instance, music copyright may require models that using streaming data and royalty revenue to assess value. Second, for IP to circulate reliably in the market, information on ownership and transfer history must be easy to access. Under Article 54 of current Copyright Act, copyright transfer can be registered and gained the third-party effectiveness. However, the registration system provides only basic information and it does not give financial institutions the complete ownership history. Overall, this lack of transparency creates uncertainty and weakens the use of copyright as collateral. Therefore, more accurate and transparent disclosure system is essential. Third, in the early stage of market development, it would be beneficial for the government to support credit for IP right holders through guarantee system and assist recovery through the disposal of collateral. These measures help reduce financial institutions' recovery risk. For copyright, loans could be issued based on the guarantees from the Korea Credit Guarantee Fund, following recommendations from the Korea Creative Content Agency. However, loan ceilings are limited to approximately $700,000 US, meaning such guarantees apply mainly to small-scale financing. So, expanding the scope of ceiling of this guarantee should be considered. As mentioned earlier, in the case of patent, government supports recovery program like collateral IP recovery supporting program are already in place. Is that the government reduced bank recovery risk by purchasing and disposing defaulted IP collateral. Such programs should also encompass copyright and other IP to further reduce financial institutions' risk. Fourth, beyond conventional collateral loans, we should explore other IP asset-backed securitization, such as using future royalty cash cow to create new financing institutions. This gives right holders a wider range of financial options. Korea's Musical exemplified this innovative approach. Musical was established in 2016 as the first platform to sell beneficiary certificates backed by music copyright royalties. Today, Musical continues to grow, managing around 1,500 music copyright with cumulative transactions exceeding roughly $27 million. Musical's case demonstrates that potential of innovative IP-based financing models, and we expect more initiative like to emerge. Korea has long pursued to align its secure transaction legislation with UNCITRAL guidance. This includes the 2012 Act on Security over Movable Property and Claims. It has many elements of UNCITRAL legislation guide on secure transactions. Nevertheless, gaps remains in activating security interest in intellectual properties. I would like to highlight these required further attention. UNCITRAL legislative guide allows multiple copyright to be grouped in a single portfolio. In contrast, Korea's copyright system, unlike patent regime, still requires separate registration for each copyright. Enable portfolio-based collateral arrangements would improve both operational efficiency and copyright collateral value. Furthermore, UNCITRAL legislative guide also permit security interest in future copyrights. This provides institutional flexibility and make financing possible even when the copyright does not yet exist. However, under the Korean law, there is no statutory base to granting security interest in future rights. These limitations should be addressed so that more creators can access financial support. To address these gaps, the Ministry of Justice will continue to work closely with Ministry of Culture and Sports and Tourism to improve valuation system and disclosure framework. We also consider reform that would allow portfolio-based copyright collateral and security interest in future copyrights. These efforts continue to align with UNCITRAL's standard. In conclusion, IP financing is the vital bridge that connects to Korea creative and technology thanks to capital market. By establishing valuable system for non-patent IP, addressing recovery risk challenges, and building reliable IP market through transparent disclosure, we aim to advance Korea IP financing framework. Thank you for your attention.
Thank you very much, Mr. Shin. So now we have our next speaker who has joined us online. It's Ivor Istuk from the World Bank Group. So Ivor, can you hear us?
Yes, can you hear me?
Yes, very clearly. So please, you have the floor.
Thank you very much. Let me just share my screen. Can you see the presentation?
Yes, we can.
Perfect. Okay. First, polite apologies for logging in for a couple of minutes late. Had some issues with my IT equipment. Good evening, everybody from Washington, D.C., where America is celebrating their Thanksgiving holiday. Or good morning to you over there. It's my pleasure to be on the panel and with my esteemed colleague, and I will present you on what World Bank sees as policies that can potentially unlock finance against IP. And as you will see towards the end of presentation, I believe that there is a lot for the global community to learn from this region, Korea, Japan, among others. So to set the stage, I think why it's important to state why is it important to look at IP and how this can be leveraged in intangible assets in general, and how can this be leveraged to access finance. Based on reports from relevant international bodies, World Intellectual Property Organization included, firms are investing more and more in intangible assets, and actually the investments in intangible assets are outshadowing and growing faster than investments in tangible assets. Just in 2024, there is an estimate that there was 80 trillion of US dollars of values of intangible assets across the world. And that is 13 times more than it was in 1996. And the growth from 2023 to 2024, year-on-year growth was 28%. Now, on top of that, we need to add something else, and that is that it is estimated that around 60% of actual intangible assets are not even properly reported or captured in these statistics. And this is due to the financial reporting standards approaching IP evaluation relatively narrowly. So they're focused on the acquired IP, but internally generated and created IP is not reported. So that by itself, together with the 80 trillion, shows what is the potential value of financing that can go against intangible assets and IP. And then at the same time, in certain markets where this has been measured, it's on average less than 13% of firms actually use their IP to access finance. The answer to that is that our banking system has been evolving for centuries, focused on tangible assets. Bankers know how to bank against fixed property, how to bank against movable property as well, machinery, inventory, vehicles, but not against intangibles yet. This creates a huge financing gap, but also it's a missed opportunity because these innovative firms, they tend to grow faster. They tend to create more value and employment if they have access to proper finance. So before we can touch upon what these policies are or should be, we need to understand what are the root causes for this gap. What are the market frictions that create this situation where we are? And I've grouped these in these 6 categories that I believe more or less capture all of these causes. Start from information asymmetry, right? So the knowledge about potential value of IP by an inventor cannot be compared to potential knowledge that the banker might have over it. So there's huge lack of understanding of potential value and how to evaluate it, how to price the risk, how to understand the risk of IP as collateral. And this takes bankers then to rely on third-party evaluators, which is my second group. And that is if they're lucky that they exist in a particular jurisdiction. If they do exist, they tend to be very expensive for these smaller innovative firms. So it's deterrent to even use them. And then if they do exist and if the evaluation is done, bankers still have lack of trust in appropriateness of those evaluations. Why? Because there are no transparent established standards of how the evaluations are done, or even the underlying data. A lot of IP sale and transactions are done privately. So in public sphere, there's not much of that data that can be used to understand and to assess whether certain valuation holds up to the standard that the banks would like to see. My esteemed colleague from Korea mentioned secondary markets. Absolutely. And we all know collateral is only valuable to the lender as much as they can expect to get value out of it in case of default and as quickly as they can get. Markets in IP tend to be relatively shallow globally. Secure transaction system, as mentioned. For cross-border finance, the fact that the way how you create, how you register, how you get priority over an IP right varies from a jurisdiction to a jurisdiction, which undermines the potential of cross-border finance. But also within a same jurisdiction, the rules could vary depending on the type of an asset, whether you're taking a patent as a collateral versus a copyright, for example. So that increases the legal uncertainty and increases the risk, perception of risk. Then we have the capital treatment. So for banks that are regulated within the Basel standards, IP and in general intangibles are not recognized as collateral that can be used to reduce the capital exposures. So the banks loans that are collateralized purely by IP, they get 100% risk weight ratio, which increases the cost of those loans for the banks, and then is reflected in the cost of finance offered to the firms. Last but not least, human capital. So I already mentioned the skills that are lacking in the banking sector, but also in many jurisdictions around the world, the skills, expertise, when it comes to evaluation are still missing. Based on these frictions, so in order to facilitate finance, the answers are, well, we need to equip lenders to be able to evaluate, either with making data more transparent, either by introducing evaluation standards that can be relied on, creating modular evaluation tools that they could use themselves, licensing evaluators to increase the reliability and trust that the banking system can have in them. When it comes to innovators, so the firms that are innovating, we need to teach them how to recognize their IP, how to recognize the value that it might possess, how to efficiently disclose that, again, by standardizing disclosure requirement, but also enable them to use it as collateral through our secure transaction systems. In order to motivate banks to actually move in that direction, we need to have risk-sharing mechanisms that spread the burden of this finance from the bank and share it with the wider financial markets. So the banks could be used as conduits, as those that provide finance after these conditions are met, but then should not be forced to hold all the risk on their books until we gain more insight and certainty in value and risk related to different type of IP assets. This risk sharing could be for insurance, for credit guarantee schemes, as my colleague from Korea mentioned, to securitization of the pool of banking loans. And then last but not least, working on increasing transparency of the secondary markets, thinking about credit information type of sharing mechanisms where maybe information of sales and valuations from the private sector market could be shared with a trusted third parties that could be regulated, which could then derive, not expose the actual data, but derive certain models how IP could be evaluated. With this, due to the time, I will close, and by restating what I mentioned at the beginning, that global community has a lot to learn from what is being tried in the region, from guarantee schemes and recovery funds of Korea, Japanese standards for public sector companies, Singapore's licensing of evaluators, to Chinese exploration of asset-based securitization of banking pools. All of these basically can be reduced to you need to share the risk, you need to reduce the uncertainty, which will then normalize IP as a financing asset over time. With this, I would like to thank the panel and the audience.
Thank you very much. Thank you very much, Ivor, and happy Thanksgiving to you also over there in Washington, D.C. So our next speaker is Thomas. Thomas, without further ado, the floor is yours.
Thank you very much, Julius. Good morning to you all. It's indeed my great pleasure to join you all this morning at this conference on how to explore how to unlock intangible assets, namely IP, the values underlying IP values, underlying the IP assets. May I first of all express my sincere thanks to the organizers and also the co-organizers for hosting this visionary platform, for bringing together international organizations, agencies, government officials, policymakers, experts, as well as academia, as well as industry players, for pooling our wisdom together, as well as ideas for a variety of topical issues, notably the issue on intellectual property financing. Thank you very much. Thank you. Well, it is an indisputable fact that IP as intangible assets has become a key driver for promoting innovation and creativity, but also for high-quality economic growth and competitiveness under the knowledge-based economy. Hong Kong intellectual property regime is highly recognized amongst the international community. As a matter of fact, according to the World Competitiveness Yearbook 2025, published by the International Institute of Management Development in Switzerland, Hong Kong ranks the 6th globally on the criteria for intellectual property rights, which represents a rise of 6 places since the current term of government has taken office in 2022. The ranking of Hong Kong actually outperforms many developed countries, and we are proud to share this achievement made by Hong Kong. But having said that, I have to say that the Hong Kong SAR government remains to stay highly committed, strongly committed to continue enhancing the local IP regime. Actually, in the latest Chief Executive 2025 policy address, amongst a series of measures to achieve our target, promotion of IP financing may be considered as a focal point, if not the breakthrough, with the aim of catalyzing and unleashing the potentials of enterprises in innovation and business development, thereby further enhancing the local ecosystem for IP commercialization and trading. Let me say that theoretically speaking, IP-like tangible assets, for example, land, machinery, has the potential of having its value unleashed for value as collateral for credit or debit financing. However, in reality, for various reasons, I guess similar to various jurisdictions outside Hong Kong, Hong Kong has yet to develop a mature ecosystem that leverages IP assets as financing instruments. As concisely pointed out by Ivor of the World Bank Group moments ago, actually the industry players face a couple of challenges. For example, the valuation is very difficult, the low liquidity of the IP assets, and also insufficient market references. Well, despite all these difficulties, in order to engage the industry players and the stakeholders' awareness and their attention, in order to focus on thinking more about these challenges, particularly thinking more as to how we should surmount these difficulties. The government's, the Chief Executive Policy Address has announced a series of issues which will collaborate stakeholders in industry player to roll out a series of measures in order to provide incentives and support to help innovative enterprises, especially the small and medium enterprises, to secure financing by utilizing their IP assets. This actually leverages, this actually is an attempt to leverage Hong Kong comparative advantages as an international financial and trade center, combined with the development of a knowledge-based economy. We believe that the promotion of IP financing will enable SMEs to unlock the economic value of their intangible assets more effectively. This slide, in fact, summarizes a couple of measures which the government is going to roll out in order to develop IP financing ecosystem in Hong Kong. The first is to launch an IP financing sandbox, which probably members of the audience heard yesterday from our director. And also, we are going to provide pattern evaluation services and valuation support to the industry. And the third and fourth and the five points basically are other supplemental measures in order to, for example, support the local enterprises to compete for our country, the China Patent Award. And we are going to also step up our external promotion to raise awareness among industry players. And more particularly, I think it's also very important to provide training to the banking sector practitioners to make sure that they understand more about IP, about the values of, about the potential values of IP, and also more particularly about the potential business opportunities underlying IP financing transactions. For the sandbox, actually, the Commerce and Economic Development Bureau, which is our policy bureau, actually overseeing the policy measures and the policy agendas of how to strengthen Hong Kong's IP regime, as well as my department, the Intellectual Property Department. We are going to collaborate with the Hong Kong Monetary Authority to launch an IP financing sandbox. Basically, sandbox, by reference to sandbox, we are referring to a pilot program or pilot project which would assist the pilot sectors, particularly the innovation and technology sectors, in leveraging IP for financing with the support of course, a number of professions in the market. For example, the banking sector, the insurance sector, the legal profession sectors, as well as the valuation sectors. In the IP financing sandbox, some of the key features that basically it would bring together key stakeholders, including, for example, banks, the IP owners, IP valuation professionals, legal professionals, as well as other professionals. They will all be engaged in providing services in support or in exploring IP financing transactions. Another beauty of having a sandbox is we are trying to create a risk-controlled environment. For example, through small-scale pilot projects, basically we're working on a trial basis. And the advantage of having a sandbox is it will enable, by enlisting the stakeholders all together, they can identify the actual operation issues and in actual IP financing cases, and also test out the possible solution, and also more importantly, collect real-world insights and data to make necessary arrangements, adjustment, I beg your pardon, in order to enhance the entire sandbox operations. And such will enable the sharing of good practice as well as experience in areas, for example, in valuation, in risk management. It will provide a reference point in order to prepare the market to explore and further develop, for example, appropriate valuation standard and framework in future. And we hope to actually gradually establish an ecosystem that supports IP financing locally, particularly promoting further development of financing of IP assets amongst industry players. The second areas which we are going to expand resources is actually the government will appoint the official operation of the Hong Kong Technology and Innovation Support Center, which is going to be operate officially next month in December. We're going to support the centers to provide local small and medium enterprises, the SME, with patent valuations. Basically, the patent evaluation will be based on national standards. And second, we're going to support the center to launch a 2-year pilot program in order to provide the support for example, patent valuations, which can be taken as an important reference data or reference materials for the banking sectors to make reference in considering possible IP financing transactions. By reference to the term patent evaluation services, actually the aim is to provide a more transparent and reliable foundation for patent financing, and thereby facilitating the commercialization of IP as a financial asset, as well as to enhance the market acceptance and confidence on IP financing. Well, by offering qualitative patent evaluation and providing support in quantitative valuation, business will also gain a deeper understanding of the values structure of, for example, their patents. It will enable them to better leverage their patent portfolios when undertaking intellectual property trading or commercialization, or apply for the necessary financial support, which would ultimately help them achieve technological innovation as well as market expansion, as well as exploring market opportunities. And the combination of qualitative patent evaluation and also qualitative patent valuation will deliver more comprehensive and detailed analysis of patent values, which will provide a more reliable basis for IP financing decision, particularly on the part of the banking sectors. The patent examiners of our department, the Intellectual Property Department, will support the Hong Kong Technology and Innovation Support Center in providing the qualitative patent evaluation service to eligible applicants of patent valuation under the patent evaluation scheme. Well, basically, by referring to the qualitative patent evaluation, it means that the examiners will actually look into the claims and the specifications of individual patents in order to analyze the overall quality of patents. For example, covering various, basically is 3 perspectives: legal, technical, as well as the economic value of the patents. And the method applied by the patent examiners does not directly calculate the asset value of the patent. Instead, it would provide analytical insights into the quality of patent in order to demonstrate in its quality. Quantitative patent evaluation has a well-established national standard, which is widely applied in the mainland. And the mainland experience will offer valuable experience for Hong Kong. The other area which we are going to provide support to the SME is basically a 2-year pilot program, support program. Under this program, eligible local small and medium enterprises will be able to obtain government funding support in engaging external professionals to conduct quantitative pattern valuation services. And the beauty of this scheme will help SME to better understand the actual values of their patents. And it will also provide foundational data for IP financing, therefore increasing the transparency of IP value. And it will also help reduce lending and investment risk. And as I've mentioned before, we hope by launching this scheme, it will also help enhance the confidence on the part of the banking sector as well as the financial institutions in relation to the IP assets, IP financial value. And we expect that the scheme will be launched in around the third quarter of next year. And basically, my department is devising the detailed arrangements of the support scheme. And we are going to work out, for example, the assessment criteria to vet the applications under the pilot scheme. And the support scheme will provide on a one-to-one matching basis, which is capped at the maximum value of 80,000 Hong Kong dollars. We anticipate that we will be able to entertain around 100 applications each year. Well, in view of the constraint of time, perhaps I will stop here, but I will emphasize that by enhancing the IP financing ecosystem, basically the measures taken by the government will be interconnected. This PowerPoint also contains other measures which the government is going to launch, and also we are going to expand our efforts to work together with the stakeholders in order to enhance our regime in each and every possible aspect, which we hope that will also enable the industry to explore the possibility of having a successful cases of IP financing. So basically that would conclude my presentation. Thank you indeed very much for your attention and patience. Thank you.
Thank you very much, Thomas. And we're looking forward to the outcomes of your sandbox and hope that we'll have an opportunity to share the outcomes with the other economists in APEC in one of our workshops next year. So last but not least, we have Johnson. So Johnson, you have the floor.
Thank you, Julian. JC, sorry. Thank you, Giuliano, because I learned about this program through Giuliano. He said about how boring it's going to be because of all the technicalities and so forth. And you know what? I find that, Giuliano, you know the subject so well, the reason why you find it boring, but I find it extremely exciting because I learned a lot here from all your luminaries. What I find most interesting is you guys are go to get things done, folks, not theoretical. And this is where I want to focus upon, is that we need to understand what is intellectual property. The word intellectual, it's not intelligence, it's intellectual. It's creation of something, not processing information. Property, ownership. We finance things that need clear titles. And this is where we see as a real issue. When JC invited us to join this program on IP finance, or now become IP collateralization, I said to JC, I need a team that I can work with. And I said, Giuliano absolutely needs to be invited. And then there's another gentleman called Michael Lin. And then, of course, the people that he knows, which is basically folks here in this room. Now, why is this so important? Because property is ownership. You don't finance things if you don't know who owns it. At the end of the day, you want clear title. And the problem with intellectual property is lack of title, clarity. You say, what? Wait a minute, is that true? Absolutely, it's true. Think about this. I use this example quite a bit. Kodak, value in the year 2000 worth over $2 billion USD by some of the experts on Wall Street. high quality people. 10 years later, it was valued over $2+ billion. It was sold 30 days later for only 500 million plus. What the world happened? What happened was a lot of litigation. Now, what kills intellectual property? It's called prior art. Now, what is prior art? It means that somebody actually thought about this. So it's, in other words, a challenge to the title. Imagine you finance a piece of property and someone says, no, my great uncle owns this place. Would the bankers finance it? No way would they touch it. We need clarity in title. And one of the biggest issues is because of the fact that people look upon this with the thinking of that, what is it really worth? What is worth is very important. But first, you need to know who really owns it. And in the world today, we need to have transparency as the title. When did that title take place? What really happened? And this is a subject that I think a lot of the folks who are trying to focus on this is not understanding the issue here. Because we need to focus exactly when did somebody think of this? Who's involved? So that no one can challenge us. No one can come over the issue of prior art. Do you know how many litigations there are in the US and elsewhere in the world? Look what happened to BlackBerry. Litigation brought them down. 4 years of litigation because someone says this is not original. Wait a minute, who's not doing their job here? Did the USPTO or other patent offices didn't do their job? Well, we need to understand the history. When the concept of intellectual property come about, what was the world like? 1600s, 1700s. It was a very simple world. So you got some ideas, you got some publications, you put into a booklet. The library was small. It was easy to search, easy to cite. But as the world become more and more complex, the information gets scattered, distributed. So it's much harder to find or cite existing ideas. And therefore, the prior art should just go away. And therefore, it's very, very hard. The idea of owning the property is that you got to have clear title. So I think what's really missing here is the fact that we're not addressing the real issue as property rights. The true definition, and this is why I'm really happy in the room with people who understands this, because at the end of the day, I would never lend money to anybody if I don't know they really own it. How do we defeat this issue of property rights problem? We need the WIPO to do what they're supposed to do, which is really consolidate knowledge to a point where we can find this, because the examiners and people who prosecute really do a good job. The problem is that they can't find all the prior art in the world. They're hidden somewhere, some publication, some obscure journal, which is what Kodak had. All these litigation led up to is, well, we're going to drag this on forever, or we're going to pay you less money. Now, if Kodak had no financial constraints and there was no litigation going on, it probably could have sold that for over $2 billion plus. The valuation was correct. The problem was all these rights. And this goes into the music industry as well. You heard these things, you read these headlines of some artists being sued for a lot of money because they said someone stole their music. So I think what we need to do is go back to the basics. The basics is really to say, hey, folks, let's have ability to be able to define what are the title ownership, so that folks in the in the financial world would not have to carry these risks. Because I, as a banker, would never lend money. And the concept intangible, it's a very tricky word. I don't know if you folks been to Macau. If you've been to Macau and you look at the sands and the casinos, they're sitting on swampland. Imagine, right? You go to the banker and say, folks, I'd like you to lend me money because I want to put a building on a swampland. Well, that's about as intangible as it gets. So what happened? The concept was sold. They finally figured, okay, we can do these things. So ideas, everything in this room is because knowledge was passed on from one generation to the other. And the previous gentleman mentioned about the valuation. Absolutely. $80 trillion of known IP. That's a tip of the iceberg. What's underneath that iceberg is all this intellectual property that's not known. And we have no ability to service that industry. Why is that? Because the intellectual properties program of the world is antiquated. It's seriously antiquated. We're dealing with 1800th century ability to measure things in the world today. But we have computers. They don't have airplanes back then. The IP system is broken, frankly speaking. I mean, imagine that, right? You put wooden wheels on a Ferrari. It wouldn't go very far. So we're not addressing this issue. People talking about whether or not AI should be owned by machines or ownership. I mean, these are silly questions, but yet time is wasted on debating these things. So what I'm really saying is that I think what we need to do IP finance is really to go back to the basics, recognizing how do we make sure to mitigate the risk of the financier? How do we do this with experts like yourselves really getting involved in the different economies and not have the economies work in silos? Because working in silos, you solve your provincial issue, but doesn't solve the global, because intellectual property is global. You have medicine, you want to serve the whole world. You don't want to serve one particular area. And I'm a banker, I want to finance that. Now, how do you do the valuation? There are a lot of experts out there that can do the valuation part of it. Standards are important, but I think what we need to tackle first is to help get the community. In other words, folks like yourselves start to really merge into the intellectual property world and start to really look at this as opposed to working in silos. I mean, it's the first time I've been to such an event. I love it. I hear what you guys are saying, and I find it very pragmatic. I'll tell you, I go to WIPO events and I find it extremely boring. Why is it boring? Not because I know the subject so well, because they're talking about things that are just repetitive. I mean, I know the world is different. We all know that, but let's talk about what is common. What is common is we have an agreement that you can kill a patent with prior art. Okay, you can kill all IPs, someone already thought of it, because an intellectual property piece is talking about novelty, not obvious, something that's different. It's like someone claiming a piece of land that no one ever knew about. There's no ownership. So let's go back to the basics. Let's understand what we're dealing with here. Let's unleash the power when intellectual property can do. We need medicine. We need a lot of things, and this all needs financing. And I use this little story. Think about back in the 1700s. Somebody goes to a banker and says, I'd like to have some money, hire some people, build a boat, and I want to sail east to bring back some silk and so forth. Think about that. The risk those bankers were taking. That boat could sink, could be pirated, goods come back, maybe outdated, but yet they financed it, didn't they? And wow, the wealth creation, the service it created, that's very intangible. I mean, think about that. I like to make a boat and go to the east. Like, you don't know the planet on your side is even there, but yet they did it. And this is what I'm saying. We're in the brand new era. This all can be done, but I think we need to shake off some of these legacy thinking. And intellectual property needs to recognize the journey, when the idea came about, which is priority date. So I want you to think about these key words here, priority date. When exactly it came about? Okay, the prior art. So you need to explore these things. And then, of course, there's this issue of trade secrets. Trade secrets is the genesis of all intellectual property. When the world's largest foundry, TSMC, files a patent, they don't tell people how they make it, what temperature, what gases they use. That's all trade secrets. Most popular examples like Coca-Cola, that's all trade secrets. But yet, nobody talks about trade secrets. There's no registry for trade secrets. I mean, it's kind of silly, isn't it? So the genesis of our intellectual property is trade secrets, but yet we're not dealing with it. You see what I'm getting at? So I think it's really exciting that we can work together and see how we can do this and help the various industry. Nobody starts out as a big company. Google algorithm is a secret. So I think we're on a great journey. There's going to be a lot of great medicine, and we need to work together. And again, it's exciting what we know we can see. Thank you very much.
Thank you, Johnson. We're actually on time for the break, but are there any burning questions from, yes, Jade?
Good morning, everybody. I think my question is actually to Thomas and Doh-Uk, probably. I think you mentioned sandboxes, and I think some of the initiatives that the government of Korea has actually been promoting is actually the government supporting these kind of transactions and supporting to build trust in IP as a possible collateral. Do you think this applies to other types of assets as well? For example, new types of assets that we're discussing in the video context, and that's the first question. And then the second question is, not all of the states actually have the luxury of having been able to launch sandboxes and testing the grounds. I think especially for developing countries that do not have the ecosystem for IP financing, when there is no legal framework, they don't have the testing grounds. And I wonder whether you have anything to say for those kind of states where they don't have that luxury.
Well, thank you indeed very much for the questions. I think this is a very interesting point. Maybe I'll address the second question first. I would say that amongst the various jurisdictions which we have surveyed, there are indeed different approaches as to how to promote IP financing. Of course, one of the, for example, in our country, China, in mainland China, as well as probably in Korea, and also in, for example, in other some jurisdictions, the government will provide support, funding support, in order to, for example, act as a guarantor, in order to mitigate the potential risk to be faced by the bank. And some governments, for example, because of the financial resources constraint, I would say that the most important thing is to engage the industry players, first of all, to understand more about IP, to understand more about the potential values of IPs. I would say that sometimes, probably not sometimes, probably most often, it is because of the lack of adequate understanding, and it's also because of the lack of sufficient rapport and confidence among the industry player, that they are quite hesitant to, explore the possibility to having IP financing. So instead of, for example, the government acting as, for example, guarantor or as an alternative to launch projects, pilot projects like Sandbox, I would say that, well, we need to work together. I mean, of course, the government will have to play a role to talk more about IP, to promote more promote more about IP as intangible assets. I think that's very important. That will also enable the banking sectors, financial institutions, to know more about IP, to know more about the potential value that they can leverage, and they can make use of this opportunity to explore new markets as well as new business opportunities. I think that will be one of the key areas which I think we need to work on.
Thank you for your question, Jay. As a policymaker, I want to raise this the issue also. In Korea, we not only we just recognize not only copyright but also all types of the digital or intangible asset. So we are keep continuously efforts to recognize all types of the asset to as a collateral or financing. So, and I will keep you updated for other events.
Thank you very much. We are finally coming to an end. So this has been a very fruitful session. Let me just say a few words about summary. So I think we talked about the challenges, the lack of robust mechanisms to strengthen confidence in the use of IP, including issues like prior art, lack of secondary markets, fragmented, uncoordinated rules, the lack of information and awareness, and also issues like the valuation frameworks. And then I think we also discussed the key elements of strategy to move forward in order to develop IP as an asset class by deepening the market. And that involves creating the enabling ecosystem, which has a lot of components, including the legal and regulatory frameworks, valuation frameworks, disclosure system, market infrastructure for securitization, risk-sharing mechanisms. Also, I think important is the education of the market participants and support for MSMEs in order to facilitate their uptake of IP finance. Learning from experiences of economies in the region. For example, Korea has been mentioned, also Japan and Hong Kong, and alignment with international standards, including the UNCITRAL standards. So I think the trends are very encouraging with the growing realization of the need to finance more innovation through IP-based financing mechanisms. And of course, the initiatives that are coming up to start the process of developing these enabling ecosystems, like, for example, through sandboxes. So on that happy note, ladies and gentlemen, please join me in thanking our panelists for being here with us. Ivor, Istuk, Mr. Doh-Uk, Shin, Thomas, Tsang, and Johnson Kong. Thank you all very much.
Good morning, everyone, and welcome to this panel on access to credit, trade finance, and digitalization. These are obviously large cross-cutting issues we've already discussed quite a bit over the last day, but we've got another wonderful panel here to discuss what happens when you go from an international standard into the field, actually dealing with governments to implement them, and then, of course, actually seeing what's happening on the ground and whether they're achieving what they're meant to achieve in relation to parties both providing finance and receiving finance. So, of course, from the legislative perspective, we have the UNCITRAL model law on secure transactions, we have the model law on factoring, and early next year we will have the published version of the model law on factoring guide to enactment. For UNIDROIT, for UNCITRAL, for the Hague Conference, we set these standards, but we don't have the resources to be in the field and actually implementing them, and that's why we rely on our friends at the international financial institutions and at banks and the private sector to actually go out and assist with the on-the-ground work required for these instruments to actually have some sort of effect. So we have a wonderful panel today. You've already got their CVs, so I'm not going to waste time with long introductions. We're going to try to stick to our 10 minutes each, so we have some time for discussion at the end. So we're going to hear from the World Bank Group, the Asian Development Bank, the European Bank for Reconstruction and Development, and the Bank of China. Without any further ado, let's jump straight in. Murat, the floor is yours.
Does that work? All right, there we go. Thank you very much, Will. Good morning, everybody. So as I was mentioning in my intervention yesterday in the morning, International Finance Corporation has somewhat shifted its focus a bit, working more towards directly with financial institutions. So obviously for many decades, we've been supporting governments at the policy level, designing and implementing effective legal regimes, setting up the collateral registries, and working sort of more at the high level sector level capacity building for financial institutions, businesses, etc. But these days we are kind of moving a little bit notch down, focusing primarily on working with banks, non-bank financial institutions, those banks and NBFIs who are interested in deploying trade, supply chain finance, asset-based finance products, helping them pilot these programs, design these products, roll them out, and underpin these programs with the right necessary technologies. And when I talk about banks and NBFIs, I don't mean, of course, the very large banks like Standard Charters or the HSBCs, because they're the ones who actually invented the supply chain finance and asset-based finance program. They don't need any advice and technical assistance. I'm talking about smaller banks, regional banks in countries like Uzbekistan, Jordan, and South Asia, and many other markets where these banks have obviously have a certain menu of products that they can offer. On the trade side, they would have some kind of letter of credit, export-import financing programs that they would offer, some kind of working capital probably as well. But if we talk about supply chain finance or asset-based finance, and we approach them to speak about their interest, for example, in factoring or purchase order finance or programs like this, they would not be aware of this program. So it will take some time for us to really explain these programs in details for them to really start wrapping their head around it. And when they do, they ask several questions. So practical questions in terms of how this bank can actually launch these programs. So from the legal standpoint, very often we would hear when we speak about factoring, especially any kinds of receivable-based products, they would be asking questions on, so if I provide this, let's say, discount to my supplier, but what if the buyer includes in the agreement a clause that prevents the assignment to start with? So something very basic like that, they may ask. If it's a reverse factoring program where you have an anchor buyer in the arrangement, they will wonder, as I mentioned yesterday in the example in Uzbekistan, so the bank would ask the question, how are we even allowed to do this kind of scheme? Yes, we understand there's a receivables purchase contract, but what about this whole master agreement with the buyer when the buyer takes this irrevocable payment undertaking? Who is our client in this arrangement? Is our client a supplier or a buyer, or is it both? How do we account for this transaction? So all these kind of questions are being asked. And even very basically, for all kinds of receivables purchase-based transactions, the banks will be asking us, oh, yeah, they will be wondering whether true sales, in fact, are even permitted. Right, so that's actually one of the questions that everybody would be wondering, whether a bank will be able to actually purchase outright these receivables. So some of these questions obviously are quite important, and the answers to these questions are found in the UNIDROIT and UNCITRAL standards. And as I mentioned yesterday, having a legal framework for secure transactions is a condition precedent for any of these products to see the light of the day. But this is not the only thing. It's a condition precedent, but the success, full deployment of these programs will depend on other factors. Again, the regulatory stance, the capacity of financial institutions, and quite importantly, technology. So in the session, we'll talk a little bit more also about how the digital platforms and systems actually help financial institutions advance these types of programs and products. So specifically when I'm talking about products, I just want to make sure that we're all on the same page in terms of what kind of programs I'm referring here to. So the easiest, I guess, would be simply to refer to the ICC, International Chamber of Commerce, standard definitions of supply chain finance. So there are 8 products that are included in there. And these are typically the ones that we would normally try to deploy with our client banks. So ICC developed, so they kind of put these different products into 2 buckets. So there's one bucket that is based on receivables purchase. So you have programs there like factoring, reverse factoring, invoice discounting or receivables discounting, and forfeiting. And then within the second group of programs, they are based more on traditional sort of devices like loans and advances. And there you'll have advances against receivables, loans advances against inventories, distributed finance, and purchase order finance. So in reverse factoring, you will have, as I mentioned, 2 agreements. You'll have receivables purchase agreement between the bank and the supplier. And then there will be another agreement with the buyer. Buyer undertakes to pay to financial institution on the due date. That's just one illustration of the receivables-based purchase product. And on the other side, let's take purchase order finance, for example. So you'll have a company that needs some working capital. They need something to produce a product. They have a buyer of the product, and the buyer places the order. And so the bank provides financing to that company so that after they have confirmed that this purchase order, in fact, is a valid authentic purchase order, and based on it, then provide financing and take different kinds of security, whether it may be that actual raw materials or inventories, and that receivables, obviously, that will be generated after the goods are sold. So it's a combination of pre and post shipment. So these are types of products that we would normally like to deploy, but when we present them, all of them to banks, some of them might be quite cautious about certain programs and more sort of receptive to some other programs. And one thing we've learned is that this sort of low-hanging fruits, from this wider menu of the programs are typically payables finance reverse factoring program, precisely because of the nature, the risk profile of the reverse factoring program. You don't really take the risk with the supplier, you take the risk with the corporate anchor buyer. That's a different risk profile. The trick, however, here is to make sure that you can onboard effectively the buyer into this transaction, right? So that's actually really part of the advisory that IFC puts forward, is really to explain to banks how you would create this interest on the part of the corporate anchor buyers through demonstrating what we call the economic value addition. So creating this sort of pitch book really to onboard this anchors. So, and once they are in that system, then it really can be very well automated through a platform. And I'll just talk about this platform part, the technology part in a while. But just very briefly, so just going back a little bit maybe to some critical differences also on the legal front. So so for banks, if you look at, let's take a distributed finance program, for example, or purchase order finance, where you have some kind of tangible asset, right? So with receivables, it's fairly straightforward, right? You can control the cash flows and so forth. But with the inventory and purchase order finance, it might be tricky, because these types of programs, they would have to rely more on a more robust legal framework, because this is really where things that we discussed in yesterday's panel on enforcement come in play, because if you have to repossess, this inventory is it becomes a totally different matter, right? So with tangible assets, it becomes more complex and more problematic than with the receivables-based programs. But still, even with factoring, the absence of anti-assignment clauses actually can be a bit of an impediment for the development of the factoring market. But with reverse factoring, it's not a problem, because obviously the buyer will already agree to assign. This is part of the whole thing. So the lowest hanging fruit is that reverse factoring program. But as I also mentioned yesterday, even though for reverse factoring, many banks are super interested in it, and the fact that maybe on the private sector, private law side, it's not really that problematic, because it's mostly arranged through contracts. It's the regulatory part that typically is the one that needs to be addressed. And unless the central banks, and again, example from Uzbekistan, comes to mind, where lawyers of the bank just simply blocked the transaction until central bank intervened and provided a very clear sort of guidance that it's okay to sort of venture in this kind of products. So moving on to technology dimensions. So this becomes actually quite important. So I mentioned that for IFC we have moved this notch down to designing these programs at FI level, but we still think it's quite important to work with policymakers and regulators and some other government agencies to create maybe national technological solutions. Couple of very good examples that we've seen how it worked well in countries like Turkey, Mexico, China. Even in Hong Kong, I think there is a similar platform exists with the Hong Kong Monetary Authority jointly with financial institutions. I think they launched this program several years ago. And it works really at the national level and provides financial institutions with the ability to tap into this technology with their products. It can cover all kinds of programs. It starts typically with reverse factoring, because this is really a product of choice for most banks for the reasons I've just explained. But it can also be expanded to cover purchase order finance, distributed finance, and other receivables purchase-based finance programs as well. So it is a kind of a national program that provides an illustration and a needed demonstration effect early on, because some of the banks may not be willing to invest large amounts of money at the outset in this technology solutions. So when you have something that's available publicly, that might really create an interest, and especially if this is done by the central bank, as it has been done in China, for example. Because if the regulator is really behind it with not just the policy, but also technology, financial institutions have become super comfortable starting and deploying these programs. But the national platform, it may be quite important. But what we've seen in Uzbekistan, actually, because we started working with the central bank on this national platform, and they were on board, the central bank, they're still working on it. But because the sort of the buzz already started and banks started, launching these factoring programs, smaller fintech companies already appeared very briefly because they are very agile, they're very flexible. Within several months, a company that nobody heard about is already in the market and actually provide pretty solid solution. It might not be the best technology solution, but nevertheless, it's something that can really provide for the right underpinning for these transactions short term. So several companies already servicing pretty much all this, hundreds of millions of dollars of factoring transactions that popped up pretty much in the less than a year in Uzbekistan. So basically, as I mentioned, all these different variables are quite important. So the private law, the regulation, the capacity, and technology. And they really play out differently depending on the type of product that we're talking about and depending on the context. So our role, as we see it, is really just to correctly identify where these gaps are, which of these particular programs and products have the greater potential for early uptake, and then work with 2 or 3 financial institutions to create this demonstration effect. And then we can see how these markets can be created going forward. So I'll stop here.
Thank you so much, Murat. It's interesting to hear that these same issues arise time and again, interaction between private law and regulation, enabling of different products that are specific to each market, problems, or not problems, but issues with digital platforms, whether they're centralized or not. We also understand that these arise in many different contexts in different jurisdictions. Now let's move on to the Asian Development Bank experience and Angelia, who also probably speaks with her private law hat on as well, having just come across from the private sector.
Yes, thank you, William. And I think I'm just going to follow the order that Murat set out and just sort of take a step back in terms of this whole discussion on standardization and the importance of international standards. Just some statistics for us to bear in mind. 80% of trade needs trade finance. So trade finance is critical to support trade. Trade has 2 aspects, the financing aspect and the risk mitigation aspect, both of which are critical to supporting trade. Now, if we think about standardization within trade, there were 2 in history, right? 2 times there were great upticks in trade. One, when there was an implementation of UCP, the first version of UCP was in the 1930s, right? But when you had standardization amongst the banks as it grew in acceptability, you see trade increase because there is greater certainty from a cross-border transaction perspective. When did you see another uptick in trade? When there was a standard size for container shipment. So all the work that UNCITRAL has done is super important, UNIDROIT, and all these standardizations, I can tell you from a practice perspective, was extremely important. And I'm speaking as the ex-head of legal for Trade for Standard Chartered Bank, the one that knows all the trade stuff, right? Now, drilling down into trade again, you will often hear us talking about merchandise or goods trade. There is another kind of trade, which is the trade in services. Yeah, there's another trade, which is the trade in services that we also need to focus our attention on. And that's particularly relevant when we're talking about using receivables as a financing product, using that asset, to improve access to finance. One other thing that I sort of want to focus on is the practical considerations, and I hear what Murat's talking about. As a practitioner, I found that there was so much at a high level, but very, very little understanding at the ground level. And I have dealt with regulators for a better part of my career. And I realized that, with all due respect, most regulators, they are fresh graduates who scored really, really well in school and come and ask me questions and okay, do you understand how banks operate? So it's getting the regulators, the legislators to really understand how banking works on the ground when you're dealing with the SMEs, with the people who actually have to live with the issues from a day-to-day perspective. So some of the practical considerations that we see, trade finance usually has very short terms. we need fast turnaround. We're dealing with volume and usually very small size transactions. So if the processes are very cumbersome, it's not going to be very effective for trade. The bargaining powers are very, very different. And the commercial relationships are such that usually the person who's asking for finance says, can you please not tell the buyer that I financed the receivable, right? Can you make sure you don't notify them? So undisclosed financing is quite an important aspect. And I really, really want us to focus on supply chain finance, and particularly, you know, when Murat broke it up into what the Global Supply Chain Finance Forum breaks it out into two broad categories, the receivables purchase side of it. And just a little trivia, I was actually part of that drafting committee for the Global Supply Chain Finance Forum. There were 40 bankers on calls, you know, through day and night across the time zones, trying to standardize the language, which was very, very inconsistent some 10 years ago. And why is supply chain finance so important, so critical? Because it allows this magic of being able to substitute the credit risk of a small medium-sized enterprise supplier, and you substitute the credit risk for the strong anchor buyer. And suddenly, not only do you reduce the pricing of the finance, but you allow this small supply to actually have access to finance, because the cost of compliance for each customer in a bank is now quite ridiculous. The last I heard, which was maybe 6 years ago, is that it costs about $10,000 per year to maintain KYC and, you know, just sanction screening one particular customer. And your SME is never going to generate those kinds of revenues for you to want to bank an SME. So we have to think about those very, very practical considerations also. And that's why, to Murat's point, right? How the banks look at KYC. Who is my customer? How do regulators look at KYC? How do we have this global legal identifier? And all of those issues need to come to bear, right? We need to differentiate international trade, domestic trade. The risk of, you know, knowing your customer from an AML perspective, the risks of frauds need to be separately identified and addressed accordingly, because the banks all deal with risks. So what do we need to do in terms of implementation at a domestic level? And it's really wonderful to hear how IFC is sort of bringing it one notch down. From my perspective, I would like to bring it 2 notches down, right? I would really, really want to sit with credit officers. In my career, 15 years career in a bank, my credit officer was my most important partner. If he or she did not understand the credit risks and how we could mitigate the credit risks, no deal's going to fly. I had to take that credit officer along with me. Trade finance is also quite unique because it actually depends on the product life cycle and the asset life cycle. If I were to juxtapose a loan agreement, you set up the loan agreement, everything is in the 4 corners, all your security documents are in place, and then everybody's done, except for the operational when disbursement occurs and some, you know, ongoing credit monitoring. In trade finance, it's different. One of the key questions I'm asked and I have to answer again and again and again in receivables purchases, Angie, when does the asset even come to life, arise? What is a receivable? And if you think about it, most credit officers were like, okay, I can tell you when the inventory is there. I can tell you when the car and all the raw materials are there, but I could tell you when the receivable arises. And we actually have to go about explaining to credit officers, well, we actually have to conduct the due diligence. We actually have to look into the contract. We actually have to determine when the payment obligation arises. And that's really getting down to nits and grits. And then, the credit officers will go, okay, I don't have that many lawyers to review each and every contract. How do I differentiate between a large ticket item, small ticket items? How do I consider my dilutions and all of this? So we actually have to sit the credit officers down and go, okay, let's look at this. How can we, and I've said with the regulators, how can we tell the regulators we are being prudent in terms of how we are assessing the risk weight of each of these assets? How do we actually determine that these assets have arisen? Then you go to the next step after having dealt with it, and I do apologize if I take too much time, right? Operationally, how do I staff up my people? How do they know when I monitor, what I monitor? How do they raise up the fact that, hold on, I don't think this receivable is quite right. How do I raise it up? How do I value that? So we really have to get down into the nits and grits, because trade finance really, really does have certain peculiarities. And truth be told, Stan Chart would never want to share that information with a local or domestic bank or regional bank. It's a competitor. So the problem, and I do realize the payables reverse factoring structure is really good, but that's also keeping the divide between those who know and those who don't know, right? And that's the other trouble I have, right? We have to get down to getting the local and regional banks to understand it, but we really have to get down to nits and grits, because when I speak to the local banks and the regulators, they go, I have no one who can tell me what to do. I cannot hire people from Stan Chart. Stan Chart's I'm not going to a regional bank. I'm not going to a domestic bank. It's going to hurt my wallet too much. And that's understandable. And it takes so much. It's the systems, it's the operations, it's staffing at every level to get them to understand. Once you clear the banks, then it's the business associations, right? How do the small business enterprises negotiate their contracts so they actually give rise to a receivable that is actually bankable? So we really have to educate everybody across the board, because trade finance is very real. It's very detailed. It's very live. It's really dependent on so many things. And we also need to focus on trade and services, which is a growing and very, very important sector. I'm done for my soapbox. Thank you for listening.
Thank you, Angelia, for taking us 2 notches down and pulling back the curtain to see what's actually happening with the credit officers in banks. It's so interesting to hear that even within the banks, you're having the same conversations we had when negotiating in model law on factoring, and say, when does the receivable arise? And one bank will say, oh, it's obviously when the supply contract is into it. So, oh, hang on, no, it's not. It's it's when the input. And so it's interesting to see that even on the ground, those same conversations are happening within even the major banks. Let's turn now to the EBRD experience. Milot, floor is yours.
Thank you very much, Will. I'll take it 2 notches up now, back again. Not sure if that would be very helpful, but at least that's where our experience comes from. And I think that's where we can, add value to the discussion today. So my name is Milot, for you who may not know me. I'm a principal counsel at the EBRD's Legal Transition Program. The EBRD's Legal Transition Program is essentially a team of specialized lawyers handling legal and regulatory reform in about 40 different economies where EBRD operates. We've been around since the, I would say, early 90s, and we've been doing secure transactions since then. So we have accumulated a lot of knowledge and background on the what works, what doesn't work when it comes to secure transactions reforms. We've been handling products as factoring since, I would say, early 2010s. So even there, we have developed a little bit of an understanding and a track record of, really looking at the trajectories of uptake following legal reforms, following factoring laws, factoring regulations in various economies, in vast sort of geographic regions. But essentially, so maybe I'll go to my next slide. I get control the slides from here. Okay, can't really see much. Seems like there's a mishap with the slides. But I'll talk through them. So essentially, as I mentioned, our track record, we do legal and regulatory reform. We also have teams at the EBRD that do especially risk sharing in terms of trade finance and through our trade facilitation program. So from the legal transition team's perspective, we work with regulators, we help with laws and regulations, we help implement best practices and standards that are implemented and produced by the likes of UNCITRAL and UNIDROIT. But we then go on the ground and speak to regulators and try to promote and make sure that those standards then fit within the context of that particular economy. And when it comes to products such as factoring, we have kind of, I would say, two types of jurisdictions where factoring has been existing and there's banks that really know how to deliver it. And in those jurisdictions, you would be surprised to see that there's really not a lot in the law when it comes to factoring because there's a market understanding about it. Banks know what they're doing. They're happy with what's on the law, but sometimes they want less because they want more flexibility in how to do things, and potentially also less incoming competitors in the market. But then we have jurisdictions where there's little to no understanding about the product, and that's where what we've seen from our experience is that really legal and regulatory reforms being inherently long-term processes, 3 to 5 years, you can't afford to essentially go and sit 3 years with a regulator, draft a law, send it to the parliament, get it passed, and then start to work on the update. So essentially what we're doing as part of our legal and regulatory reforms programs is we're working on the design to ensure that the entire lifespan of the project is essentially one big market awareness and capacity building program. And what you cannot see here are essentially the various deliverables that we have as part of our project. So we do assessment at the beginning. That's one deliverable where we look at the country analysis. We do a comparative analysis with various jurisdictions. Then we have action plans. We have recommendations. And then we have also trainings. And if we just look at that, I think from the first glance, it looks like, oh, there's a training component towards the end of the project. That's fine. But the way we actually narrate our impact and our work is that essentially, even when we are delivering that concept paper, which we do usually at the beginning, where we provide an analysis, that's a capacity building for the regulator. This is where we tell the regulator, these are the gaps. This is what the product is about. These are the gaps. This is what you need to do. This is why you need to do it. And then we share that with the market and we provide feedback. We get feedback from the private sector. So this is done now, like essentially building that anticipation with the market as well as to what's coming. What do they need to get ready about as well and take their feedback into account to then develop a draft law. And when the draft law is again prepared, it's a long process of, again, a lot of discussions with the regulators, the ministries. And again, this is where, and this is, if this is not capacity building, I don't know what it is. We may not really, the words and the deliverables, the way they are named may not show it, but these are really like long calls and discussions that we have with them in trying to explain why they should do what they're doing. And then again, we have other discussions with the private sector, again, to create that anticipation. And then over time, while this like 2 years passed, there's a momentum that's being built in the market so that when the law finally passes, banks already have been preparing or been gearing up about what's coming. And then we put this all together with essentially through our trade facilitation program, who essentially support their partner banks with digital transformation related advisory work. So essentially setting up their ERPs, their IT systems, so that they don't do factoring through Excel spreadsheets, which is like the most sort of used way that we see, but they actually go and automate things so that some of the processes and costs related to that go down. We do trainings, again, to private sector, but also we invite public sectors that we engage and try to have this dialogue between public and private players. Again, advisory, we have this TFP Innovation Lab, which we launched this year, where we essentially invite partner banks in the really sandbox type of environment where they can try and test the various innovative products. And then again, we also engage in pilot transactions. And when we combine these two, is that we see there is the whole legal reform process is a tool to create this momentum essentially for the product to take up. And we've seen, Murat mentioned Uzbekistan. We've seen this essentially play up in Uzbekistan. We started in 2022 also with IFC. 2025, when the law this year came into force. 2022, the volume for factoring was 60 million. 2025, when the law just came into force, 600 million. And I think there, I would really like to, and this is US dollars, I would really like to also reiterate what Murat said about the regulatory proactivity. There's a very proactive regulator there who's like really pushing and forcing, not forcing, but really pushing banks and telling them and guiding them as to how they should really start to deliver and offer this product. And we have new market players creating the conditions for them to offer factoring as well, some competition as well. And then we go, all of this would still not be enough if it weren't for the digital public infrastructure and all the efficiencies and how it really brings down a lot of these barriers to roll out. What we've seen in a lot of jurisdictions is that absent this, it's really, you have factoring being offered on some corners of some banks to very trusted clients, and it really doesn't scale up. And that's because there's high setup costs, some operational complexity as well, which now we have very good IT solutions that are tailored for this. I mentioned the likes of ERP platforms, for example, which automate a lot of the processes which are either paper-based or very cumbersome and manual. And then legal and regulatory risks, we have laws that really foresee receivables registries to address the priority issue among creditors. And then you have fraud risks, which the likes of the e-invoicing systems and e-invoice registries. And again, likes of digital identities will help combat that and again, automate this whole process. And then client risk and protection, we have invoice marketplaces, again, digital marketplaces, which are being implemented in many markets. And when we bring all of this together, we're really lowering operational risks and transaction costs, but also we increase the offer and demand. In many countries where we go, we see that we ask banks, why don't you offer factoring? They say there's no demand. No one is asking me to. And then when we go and speak to corporates and suppliers, they're like, well, if I go to the bank, it's way too expensive, it's way too cumbersome, it's way too complex. And so bringing in the digital considerations, I think, really bridges these gaps between these market players and increases both the offer and demand, but also our efforts on capacity building and market awareness, I think, increases awareness especially from the supplier side to actually ask for these products, because when there's an ask, banks will be a bit more likely to act. And then we have, again, as you mentioned, the regulatory buy-in. This is all doable, and I think it's all being done. Countries like Uzbekistan, Ukraine are doing a lot of this and are really positioning themselves in terms of digital public infrastructure. But then we have also the regulatory buy-in, which in Uzbekistan, as I mentioned, it was critical. In Ukraine, we have a very engaged regulator who have been really championing the whole factoring legislative reform, which again, Ukraine as well passed a law this year, largely in line with the UNIDROIT model law. But again, we tackle the operational and transaction costs, but we are not tackling the capital cost bank, and we need that. That's a crucial element of essentially convincing banks in our countries, the local and regional banks, to actually start delivering this product. And that's where we need the regulators to chip in as well through regulatory sandbox, where they essentially may try to test these solutions in a more controlled environment, so that then they have more confidence to actually provide those flexibilities in terms of regulatory treatment, especially for receivables. And it's only when we see this in this whole entirety of the actions, I think that after all these years, I think we come to some type of a recipe, let's say, to kind of have, and a blueprint as well, to actually have something that works. We see Uzbekistan, things work. I'm very sure that Ukraine, when the law enters into force next year, will be very well placed to have a very similar trajectory of uptake. And one last point, Will, in countries where, for example, there's digital public infrastructure and the regulator is not really following, we also see that the industry themselves are actually taking action. When it comes to, for example, invoice registries, in Serbia, we were doing a Western Balkans regional factoring workshop or conference this year. In Serbia, after a very big fraud and factoring, now banks huddled up together, created a registry where they're really putting and registering their significant, I would say, exposures so that they are looking for each other's backs to actually have that market transparency. Again, it's not a priority thing, it's more like a notification that we have assigned or we are financing invoices of this particular customer so that it really creates some confidence in the market and the product can go on. But yeah, that's in a nutshell.
Thank you, Milot, for summarizing EBRD's important work. And it's always nice to hear a success story. Hearing a 1,000% increase in factoring volume in Uzbekistan after a pairing of regulatory and private law reform is very promising and music to our ears in terms of ensuring our instruments are actually having the impact we want them to have when properly implemented. We're now going to change pace slightly with our friend Jun online, who will be speaking about the implications of the UNCITRAL negotiable cargo documents project. Jun, can you hear us?
Yes. Can you
Wonderful.
hear me?
We can indeed. The floor is yours. Thank you.
Okay, thank you, Will. Dear distinguished participants, it is of my greatest privilege to be invited to the meeting, and I will introduce the UN Negotiable Cargo Document implications. I will call it NCD in the following presentation. NCD actually was proposed in 2019 by China for the purpose of facilitating multimodal carriage of goods, especially involving railway transport. The draft convention, finalized by UNCITRAL Working Group 6, was approved by the Commission in July this year and submitted to UN General Assembly for adoption. On November 21st, last Friday, during the UN General Assembly 80th session, the Sixth Committee approved the draft convention, and it is estimated to be adopted by UNGA around mid of December. A signing ceremony for the convention is to be held in the second half of 2026, next year in Accra, the capital of Ghana. And it is recommended that the convention be known as the Accra Convention on Negotiable Cargo Documents. NCD is to be ratified by at least 10 states for enforcement. The convention is significant in three aspects. Firstly, it formulates an international law on negotiable transport documents in any mode of international transport, extending the concept of the negotiability traditionally existing in maritime bill of lading to any mode of transport. Secondly, it creates the first international hard law for electronic transferable records in any mode of transport, aligning with UNCITRAL Milot principles. The convention allows NCD in paper and electronic form. Thirdly, it structures the first harmonized international legal framework for multimodal transport document. NCD is a law for document regulating the issuance, transfer, and legal effects of the NCD document. It is not a transport law about the rights, obligations or liabilities of the parties and the transport contract. To subject to NCD convention, a conspicuous reference to the convention is required, and it is applicable when the place of taking in charge or the place of delivery or the place of issuance of NCD, as indicated in NCD, is located in a state party. NCDs are documents of title enabling the holder to have constructive possession of the goods through transfer, which may enable the bank to have legal control over financed goods to mitigate financing risk. The negotiability of NCDs will enable the holder as the sole person to exercise the rights and NCDs. Third parties acting in good faith are entitled to rely solely on the information in the NCD to take delivery of the goods. NCDs are not compulsory, and an opt-in mechanism is adopted. NCDs will only be issued when agreed upon by the transport operator and the consignor. The issuance methods of NCDs are flexible, either by upgrading existing transport documents with required annotations or as independent standalone documents when no transport documents exist or when the existing transport documents are cancelled. Various stakeholders may benefit from NCD, including international traders, for example, the importers and exporters, and also especially for those located in less developed landlocked countries, and also the financial providers who may have additional collectors as risk mitigants in non-maritime transport, and the free forwarders and the logistic providers. Also, the insurance industry and the governments. I will not go into the details for the time constraints. UNCITRAL Secretariat has launched the NCD pilot project since last July until the enforcement of the convention. Up to date, 4 paper NCDs and 2 e-NCDs, electronic NCDs, were issued. Bank of China handled all the paper NCDs and 1 e-NCD trade finance related transactions. And this is a paper NCD case. An SME importer in China purchased goods from an exporter in Kazakhstan, partly by advance payment and partly on open account basis. The main carriage was by train. To mitigate the financing risks, Bank of China recommended the use of NCDs as collectors in import trade finance. As the convention has not taken effect, a tripartite agreement was signed among Bank of China, the importer, and the transport operator, agreeing that NCD be the only document for goods delivery. We recommended the use of multimodal negotiable transport document template because according to Civil Code of China, multimodal transport documents may be either negotiable or non-negotiable as requested by the consignor. The free forwarder, acting as the contractual carrier, issued NCDs using the multimodal transport bill of lading template, and the bank then granted import trade finance by paying the exporter directly and registered the NCD as collector in the central bank's security registry system. And this is the back of the NCD. It bears the terms of negotiability and document of title and the applicable laws of the carrier's liabilities in different legs and the modes of the transportation. And here is an e-NCD case wherein the FIATA EFBL template was used. All the procedures were the same with those paper NCD transactions, except for the necessary steps for digital transactions. This is the e-NCD issued. It is a screenshots of the e-NCD. The authenticity of the e-NCD can be verified by using this QR code. It took no more than 1 working day for us to complete the transaction and satisfy the importer's timing requirement for payment, and also help the exporter avoid the credit risk of the importer after shipment. And this is the back of the e-NCD. EFBL bears the terms of its negotiability and title to the goods, and also the jurisdiction and applicable laws to the freight forwarders. Transport industry responses actively towards the NCD convention. For example, Costco just released the world's first NCD template on 20th October this year, based on its existing bill of lading and the blockchain Global Shipping Business Network Platform, GSBN, by referring to UN NCD convention rules. Costco also designed 2 different sets of NCD templates subject to two sets of legal systems. One is the PRC law and the other is the Hong Kong law. And also FIATA is preparing its FIATA BL template subject to the convention. ICC Banking Commission has been actively engaged in UN NCD draft convention drafting, and I acted as ICC representative since its preparatory stage and joined the Working Group 6 later. Now, ICC has worked together with UNCITRAL, ISCAP, FIATA, and GSF, this Global Shippers Forum, on advocacy activities to promote the awareness of the benefits of NCDs and other preparation work. GSF, FIATA, ICC Banking Commission are also working on a guide on NCD for shippers, forwarders, and banks. We have encouraged members to participate in NCD pilot project, and I'm very glad that recently I had a meeting with EBRD and Milot and his colleagues regarding the NCD pilot project. I'm glad to know that they will push forward on that. SCAP has set up a designated area on its webpage introducing the pilot project. If you are interested, you can get access to that website. ICC has provided a template letter for members to advocate the ratification by their countries. And also the monitoring and developing feedback on UNCITRAL's working work regarding the digitalization of NCD has also been included as one of ICC Global Policy Commission's Work Plan 2026. Of course, to prepare for the use of NCD convention, a lot of work has to be done, including legal harmonization, digital readiness, etc. Finally, I would like to share the information about UNCITRAL Working Group 6 47th session hybrid side event, which is open to the public free of charge. It is to be held on 16th December. If you are interested in participating, you may register on the link by December 12th. Thank you very much for your attention.
Thank you very much, Jun, for that wonderful presentation on the ICC's participation in the NCD project and the very interesting pilot projects that have already begun under the draft convention. So all of the speakers have done a wonderful job in sticking to time. So we have time for a couple of questions. I'm going to abuse my role as moderator to ask the first question. So the model law on factoring adopted 2 years ago, we've already had implementation efforts in 7 countries, in Georgia, Jordan, Malaysia, Turkey, Ukraine, UAE, and Uzbekistan, with varying degrees of success. So the guide to enactment, which will be published next year, identifies some of the core features, because we know realistically no country is going to implement all 54 articles verbatim. And even though these were drafted to the model law on factoring, they pretty much equally apply to the UNCITRAL model law on secured transactions as well. So very briefly, these key factors that we think every country should consider when implementing the model law on factoring is the law should apply to both outright and transfer of receivables by way of security. There should be a clear scope in defining what receivables are, as you mentioned. They should simplify the legal requirements for transferring receivables. There should be a complete override of anti-assignment clauses in the law, and third-party effectiveness for the transfer of receivable should be determined through an electronic registry. We say you can be somewhat flexible in the rest of the articles, but we really think if you want to have an effective receivables finance law, these are the 5 aspects you need. I would like to ask the panel, in your experience, of course, every jurisdiction is different. Have you experienced particular resistance from central authorities, from governments, or from parties in relation to any of these specific key features, where there's been more challenges than others? We might start with Milot, because I know he has.
Thank you. Thank you, Will. I think so if you're looking at the regulators' resistance when it comes to various aspects of the MLF, it's the outright versus security transfers. In a lot of countries, regulators have a hard time wrapping their head around essentially including the security assignments as part of the scope of factoring laws. And this is something that we've been really pushing and promoting with them and explaining the rationale behind it. I think there's been a very, very good, emphasis on, and it was very well received at the registry. That's something that I think across the board, it's something that it has been implemented. But from the industry, what we've seen as a pushback are these anti-assignment clauses. I think in some countries, there's still a push, even while those laws are in parliament, to actually do something about it, because that essentially shifts this risk in the sense that when big buyers are transacting with suppliers, they have this power over them. But then if that supplier really assigns that risk to the bank is all of a sudden going to be a bit more insisting on making sure that those payment terms are obeyed. So these two, I would say, one from the regulator side and the other from the industry in terms of resistance.
Yeah, just maybe briefly, I think it's not just about the regulators trying to wrap their head around the notion of transfer outright or by way of security. For example, when we worked with the Ministry of Finance in the United Arab Emirates, they've decided that there will be a standalone separate factoring law. And as presented, it was pretty clear for the ministry and other stakeholders that it makes sense to incorporate in this law all things receivables, right? So it doesn't really matter whether it's by way of security or transfer outright and so forth. It had to be sort of in one cohesive space. And that message sort of really kind of landed quite well. Whereas in Uzbekistan, the idea was not to enact the standalone, well, at least our suggestion to enact standalone factoring law didn't really fly, because you already have this specific chapter within the civil code. And it is chapter on factoring, and factoring was defined there at the outset, obviously, just as the transfer, outright transfer of receivable. But then what had to happen is for us to embed under a single sort of umbrella all these different types of devices, we had to go into different chapters of the civil code. So there's a second part of it that deals with specific instruments, and there is a generic part that talks about obligations in general. So we had to go back and make some adjustments in that chapter as well and illustrate the interconnectivity between those. That was not something that really parliamentarians or a central bank even could initially understand. So it took us a while to connect all these different dots in their minds, so they finally could see that there has to be cross references between these different chapters to make sure that we actually are in line with the scope that has been designed by the UNIDROIT model.
Okay, just coming in from a really sub-variation products. The general view is that the factoring law, when it sort of conflates two issues of outright transfer and security by assignment, is that we lose the benefit of an off-balance sheet financing, which is a key focus for a lot of the banks and the sellers who are trying to get the assets off balance sheet. Within receivables purchase products, we break it down into without recourse, limited recourse, and then the other category of with recourse receivables financing. With recourse receivables financing, we see from the bank's perspective and from a legal true sale perspective and from an accounting perspective, very much like a loan to the seller. And so the bank can then flow on from there, identify the seller as the customer, do KYC on the customer, and do your credit risk analysis on the customer. When you flip it around to a without recourse or / limited recourse transaction, then whether or not the seller is a customer from a KYC AML perspective depends on how you do your product offering. You should be focusing on the credit risk of the buyer. And you should be doing your KYC and full credit analysis on the buyer. So when you conflate the two issues and you okay, everything has to be registered against probably the seller, because the seller's receivables has been sold. But you don't want the buyer to go, wait, why did you sell my receivables? Are you concerned about my ability to pay you? And it creates commercial issues. So the registry then registers something quite vague, which is not quite useful to the creditors of the sellers. Like, how do I really identify what's been sold? And then you create another level of issue for the poor seller, who's usually an SME, that if I want to get another creditor, I've got to get an intercreditor arrangement to set out which receivables has been sold to whom. So that's why I'm always very concerned about how the line between an outright transfer of receivables and a security by assignment is differentiated, because the commercial accounting effect is very different for the two products, and there are a lot of benefits for the SME to be able to achieve an outright transfer, for the bank to not have to recognize the seller as the borrower, as the party on whom it has to do a credit analysis, and to shift everything to the buyer whose credit risk should be much better than the SME.
Wonderful. Thank you, panel. We started slightly late, so I think we have time for one more question from the floor. If anyone has anything they want to ask, please, Johnson.
Yes, not a question, but just a comment. Earlier, Angela's mentioned about the various finance tools, and I just want to add that a lot of companies that are looking for finance actually are just trying to survive the valley of death. For those who are not familiar with the term, basically an area where they're trying to grow their business, and they got all these receivables or orders and such, and they just need short-term financing, and they're stuck looking for investors. But that could be in finance. So this is part of the IP finance that we're also talking about. Thank you.
Wonderful. Well, then we don't have any further questions. Then we just, I'd like everyone to thank our panel one more time. Oh, sorry. Please, Richard, didn't see you.
If I may, a quick comment. I just wanted to congratulate Working Group 6 on the convention, the negotiable cargo document convention. There's really a big need for in-transit inventory financing. I represent lenders in the US, and borrowers are really in need of that. And the law is always in a great state of confusion. And I think this will go a long way to clarifying, pardon my voice, the law. Thank you.
Thank you very much, Richard. Well, without further ado, can we thank this panel one more time?
All right, if you want to start, you can start. I will be your in-person moderator, but you have the chair.
Okay, thank you, Jay, and welcome to a panel on agricultural finance. A few months ago, I strongly suggested to the organizers to include this panel. I identified the speakers, and then I did not show up. So thanks to the organizers for the opportunity to moderate this panel remotely, and especially to you, Jay, for managing any questions that we may get from the floor. As agreed with the panelists, I will do a bit more extensive introduction to set the scene for this panel. Panels focused on agricultural finance have featured at previous coordination conferences, but the importance and focus on agricultural finance have accelerated over the last year, particularly in the broader context of achieving food security and sustainability. So let me briefly summarize a series of important events just from the last 2 months, and then explain briefly how our community, including the coordination network, is responding to these challenges and developments. First, and probably the most important event, at its annual meeting this October, the World Bank Group and the International Monetary Fund launched a major initiative called AgriConnect Farms, Firms, and Finance for Jobs, pledging $9 billion a year of commitments to support agriculture in general. This initiative rests on 3 pillars. Pillar number 1, improve infrastructure, particularly through digitalization. Some of these aspects have been discussed throughout this conference. Number 2, support government policies helping businesses grow. And number three, mobilize private capital and increase access to financing, which obviously is one of the major themes of this conference. The second important event occurred during the annual World Bank Law, Justice and Development Week, where I had the pleasure of participating on a panel with colleagues from the Asian Development Bank, FAO, IFAD, as well as UNIDROIT to discuss a toolkit we are developing on agricultural finance for policymakers and financial institutions that will be launched next July. The third important event occurred early October in Tokyo, Japan, under the APEC umbrella, which held the Food Security and Agricultural Finance Workshop, focusing primarily on access to equipment through finance and leases. This was largely a promotional event for the UNCITRAL and UNIDROIT instruments that several speakers at this conference contributed to. Our first presenter on this panel, Will, is going to highlight the key takeaways and future steps from this important workshop. For instance, increased mechanization and utilization of digital technologies in equipment increases yields, lowers maintenance costs, and delivers other benefits. Another important event just from a few weeks ago, my own institution, ILI, and the IFC co-published the Knowledge Guide on Crop Receipts, which we are planning to officially launch in a webinar on January 20. You will all get an invitation to it. The webinar is supported by UNIDROIT, FAO, and IFAD. Our second speaker on this panel, Kirilo, will walk us through the key aspects of crop receipts, illustrating some success stories and outlining the elements that should feature in the future work of UNIDROIT, as the Secretary General explained yesterday. Kirilo's presentation will explain the process of financialization of ordinary secured loans, whereby a loan typically secured with growing crops becomes a financial instrument that trades in capital markets. Fifth, intensive discussions occur regularly within jurisdictions on how to improve domestic systems, and I had a pleasure of participating in one of those in September in China in Beijing. Our third speaker, Lucy, will explain the relevant considerations and compare the aspects of the Chinese framework governing warehouse receipts and compare it with the model law on warehouse receipts. China is an example of a framework that relies on a limited number of rules, which are scattered throughout the civil code and judicial interpretation. And then finally, UNIDROIT has recently undertaken a review of its completed and existing projects that affect agriculture more broadly, not limited to agricultural finance. I'm happy to contribute to that work stream that is chaired by Henry, who will close this panel, bring in various teams affecting agricultural finance and more broadly food security together, discussing the completed and ongoing projects at UNIDROIT. He will also outline the elements of the future UNIDROIT Agriculture Financing Legal Guide, a project expected to commence in the spring of 2026. So with that extensive background, I'm turning over the floor to Will for his presentation. Thank you.
Thank you very much, Marek. We are missing you here in Hong Kong, and thank you for staying up probably very late to moderate this panel remotely. So I'll be focusing my 10 minutes on cooperation with APEC in this field, and in particular the focus of the APEC projects on the Mining, Agriculture and Construction Protocol, which is obviously very close to my heart and the heart of UNIDROIT. So taking a broad perspective at first, 10, 15, 20 years ago at APEC, you would go along and would say, encourage countries to look at doing secured transactions reform and access to credit reform. And that was very effective 4, 5, 10 years. But now we're told more and more that you cannot just go to a country and talk about secure transactions reform. You have to talk about supply chain finance, trade finance, SME finance, sustainable finance, agricultural finance. You need to talk about these more specific products or these more specific terms of finance, because the eyes will glaze over collectively of governments when they hear for the 30th year in a row how they need to undertake broader secure transactions reform. And this evolution, I guess, is also reflected in how we, when I say we, I mean not only UNIDROIT, of course, our friends at UNCITRAL have been engaging with APEC. So, excellent. So you're probably all relatively familiar with APEC. It's a 21-member economy regional grouping in the Asia-Pacific region, covering not only states, but also sort of lesser than state entities. So of course, Chinese Taipei and Hong Kong is also included as an APEC member economy. UNIDROIT, UNCITRAL, and the Hague Conference all enjoy observer status, guest status with the APEC Economic Committee. And this is a useful, at least from the UNIDROIT perspective, and I'm sure our friends at UNCITRAL would agree, APEC is a useful forum because it brings together on a regular basis a group of important states at various levels. You have a ministerial level at a very, very high level, then you have sort of senior officers, and then you have the ability to also deliver very technical work, to get the right people from the right government departments in the room to talk about how to undertake technical reforms. And engagement with APEC from the high level, with Ignacio talking to financial ministers, right down to the technical level, provides us the opportunity to promote our instruments to the right audiences. It's not always the quickest mechanism, but for us, it's quite an effective mechanism. So there's been long-standing engagement, as Marek said, with APEC, dating back at least 10 years, and not just in relation to secure transactions reform. Of course, arbitration reforms, international contract law reforms have also been promoted, utilising UNCITRAL, UNIDROIT, and Hague Conference instruments through this forum. Now, the most recent iteration of this was this workshop delivered just last month in Tokyo. It was primarily proposed by the United States, but then co-sponsored by a number of other APEC member economies. And it was focused on, as we see here, secured finance to facilitate sustainable economic growth and improve food security. It was based on a study written by AIIFL, written by Marek and Mike Dennis, focusing on gaps in the Asia-Pacific region in relation to agricultural finance, which highlighted that the Asia-Pacific region produces 53% of the world's agricultural output. But despite that, there is a lack of access to credit, especially for smallholder farmers. There is inadequate legal infrastructure, there are high collateral requirements, and there is lack of access to markets, all very common issues that everyone in this room would be familiar with. So this workshop allowed us to bring in government officials from Indonesia, Vietnam, Thailand, Peru, Papua New Guinea, Malaysia, the Philippines, China, Hong Kong, and Chinese Taipei, and allow over a 3-day period experts from UNIDROIT, UNCITRAL, ILI, ADB, ABAC, AEM, and various other academic experts to present these instruments at quite a granular level and explain how they could support the reforms being undertaken in these countries or in these economies. There we go. So this sets out UNIDROIT's work in the field of access to credit. The workshop focused on the Cape Town Convention and the MAC protocol, because of course you need the convention to implement the protocol, the model law on leasing, and then in particular, the UNCITRAL UNIDROIT model law on warehouse receipts and its guide to enactment. Of course, this also all builds on previous work, several workshops undertaken previously on the UNCITRAL model law on secured transactions, which had already been promoted through workshops organized by ILI in previous years. We also have, I just note here, leading to Henry's presentation later, so I'll say nothing more, that UNIDROIT's work in the field of agriculture and private law is not limited to secured transactions. We also have a number of other publications, but I won't say another theme because that's what my friend Henry will be speaking about. One of the big focuses of the workshop was on the MAC protocol, because as Marek said, one of the items identified by the ILI in their stock-taking study of agricultural finance challenges across APEC member economies was in relation to a lack of mechanization, a lack of access to credit to acquire advanced equipment that will facilitate increased production and output. which meant it naturally lent itself to the value of the MAC protocol. Now, everyone in this room is very, very learned, so I'm not going to go into great details in relation to how the MAC protocol operates, but of course it extends the Cape Town Convention. It allows for the creation of international interests in certain types of mobile equipment. In this context, the mining, agriculture, and construction equipment. Once you have an international interest, you protect it by registering it in an international registry. The international registry is currently being built for a very low registration cost. We're hoping between about $20 and $40, but that will be determined in the near future. And of course, once you have your international interest registered, the treaty itself provides enforcement. You can enforce on debtor default, you can enforce on insolvency, not based on the domestic law of the country, but based on the treaty, as long as a debtor is based in a contracting state. Doesn't matter where the creditor is. So even though it's quite complex in the granular detail, at a broad level, it works quite effectively and it would be quite familiar to everyone in this room. Now, one of the main ways, of course, we promote the MAC protocol to countries is in relation to its economic benefit. That's one of the main ways you can, of course, encourage a government to adopt a legal reform that's very technical if you talk about the numbers. So a team of independent economic economists, or a team of UK economists, found that if it is ratified by at least 65 states around the world, which is at the time was how many the Cape Town Convention had, we now have 90, but essentially it would involve the deployment of an additional $90 billion of MAC equipment across the world. This would have an impact on global GDP of $30 billion. Most of that, 23 billion of that, would go to developing economies because, of course, these economies are more dependent on primary industries like mining, agriculture, and construction. So what was very pleasing at this workshop was that the member economies weren't passive in receiving this information. It wasn't merely international experts speaking to member economies and member economies sitting there and hopefully absorbing the information. The way that ILI and Marek and his team designed was that it required participants in the room, who'd been, of course, funded through APEC to come, to prepare reports analysing the value of these different instruments, so model law and warehouse receipts, leasing, and the MAC protocol, on how it could assist them. And from the UNIDROIT perspective, we were very pleased to see that Vietnam had undertaken quite a bit of analysis on how the MAC protocol could assess or could address issues in relation to challenges in accessing credit under their domestic law. And they grasp onto the key value that we see of the MAC protocol, which is that it sort of works in parallel to domestic law. So you don't need to undertake a whole-scale domestic law reform to facilitate access to credit. You can just implement the treaty. You don't have to pay for the registry. You don't have to create a domestic registry. You can just implement the treaty. And as in the words of Vietnam, a quick win to accelerate mechanization while broader domestic reforms are underway. Similarly, Indonesia focused on the economic benefits, noting some of the challenges and the lack of mechanization, and importantly, challenges in leasing in Indonesia, which is important under the Cape Town Convention because, of course, leasing is one of the 3 ways you can create an international interest. So even though the MAC protocol operates in parallel to domestic law, really importantly, it also allows integration with domestic collateral registries. So those countries that have already undertaken secured transactions reforms based on the model law on secure transactions, they can link their model law and secure transactions domestic collateral registry with the international registry. So you don't have to choose one or the other. In fact, best practice, as we tell everyone, is to do both. But we like what Vietnam said is that you don't have to do both in complete parallel. You can work on them simultaneously, not choose between them, and get the first to enter into force as soon as possible. The MAC protocol, we have the International Registry Supervisory Authority, we have the regulations for the International Registry, the contract should be signed in the next few weeks. So what we need for entry into force at this point of the MAC protocol is the 5 ratifications. We've had signatures from Congo, Gambia, Nigeria, USA, and the European Union, ratification by Paraguay. We're in an important window now for the next 2 and 3 years where there is a lot of momentum behind the treaty, but we need to get those ratifications to make sure that we don't lose momentum of the project right now, which is why UNIDROIT is particularly focused on ratification and domestic promotion, including through this APEC forum. Going forward, we're hoping this won't be a standalone workshop. Obviously, you can't expect member economies to implement domestic reforms after one 3-day workshop. We want to do more of this through APEC. We want to continue to partner with our friends in this room, with the IFIs, with our sister organizations. And our hope that is if we can continue to utilize this APEC forum, maybe 2 to 3 more years, we will actually see ratifications and domestic reforms implementing these international standards. Marek, I think I'm only 1 minute over time. I'll turn the floor back over. Thank you very much.
Well, thank you, Will, for that excellent presentation, which also connected to the last presentation of the preceding panel that highlighting the need for security in cross-border transactions. And you provide another example of where a robust legal regime is necessary to facilitate cross-border deals. With that, let's move on to the next presentation, and Kirill will walk us through a relatively new financing product called crop receipts that facilitate pre-harvest financing. Kirill, please.
Thank you so much, Marek, and thanks everyone. I'm absolutely delighted to be here and honored with the invitation, and compliments to the organizers. And I know that it might be a bit stressful, and thanks for the fantastic 56th floor view yesterday. So yeah, my name is Kirill Muhamedzyanov. I'm part of IFC and representing here Ukraine Agriculture Capital Markets Development Project. I'm a project lead, and I'm also leading several other initiatives also related to sustainable finance in Europe. But let's focus on crop receipts, because I think it's a bright example of what we've been discussing during the past 2 days already. And I've been enjoying the conversation, because this conference is full of practical insights and full of innovation. And I just want to continue to be practical and show you an example of how a simple, at first sight, instrument could make a big difference. And there is a very easy task to me to fit a 10-year journey into a 10-minute presentation. So if you can start. So, and let's start with this. So crop receipt is a fantastic example of how the legal framework, the sky, can make a real difference, an impact on the ground. And let's just learn how. So first of all, let's try to understand what is the nature of this instrument. It's jumping a bit. So crop receipt can be considered a negotiable instrument that is designed to provide a pre-harvest access to finance for farmers. And it's a very essential thing, because I believe there is no single jurisdiction which would have enough of fixed assets to cover the needs in financing in all the sectors, and agriculture is not an exclusion. So that's why pre-harvest access to finance is very important to agriculture in general. So of course, crop receipts can be in various forms. It can be paper-based, it can be electronic document, but what is important to understand that these are 2-in-1. You can consider it as 2-in-1. On the one hand, it's a unilateral obligation to deliver crops or pay cash at some point in the future, and simultaneously there is a collateral side. So it is backed by future crop, which is grown. So 2-in-1, obligation and collateral. So deployment of crop receipts normally is enabled by legislation, which includes several important components. First of all, as we just said, we need to understand what's the legal characteristics of the instrument, what's the nature of the instrument, what are the obligations deriving from the issuance of crop receipts, and what are the rights of the holders of those instruments, and what should be the infrastructure around crop receipts. So registries, right? We talked a lot about registries, and for crop receipts, we need to design maybe a separate register or included in the existing register infrastructure. There are two types of crop receipts. As we just said, if we settle the crop receipt with the payment in cash, it's a financial crop receipt. We can identify the amount of payment from the very beginning, but we can also link it to some indexes, to commodity prices, to foreign currency, so it can be indexed. So with that, we will know what sum of money we have to pay at some point in the future when the due date comes. So, and with commodity crop receipts, we just need to deliver a certain amount of commodities or crops of a certain quality, right? So, and these are two different instruments with already a bit different nature. So, example of crop receipts in Ukraine is very vocal, I would say. So, and you can see the stages of development of this project. So, in what's notable here that when the IFC project started with the help of a beautiful development partner, SECO, from Switzerland, the law on crop receipts was already adopted in 2012. So it existed 3 years, but not a single crop receipt was issued. So our question was why? So that's why when we started to think about what should be the enablers, how to facilitate the market adoption, what should be the capacity building, how to build the sector capacity to use this instrument. We started with some pilots and building the plane while flying. So, and created the register on crop receipts in 2017, but by that time we already piloted in several regions of Ukraine. So, and then there is a huge market uptake, right? With the new register, we see the exponential growth, and we reached pre-war $500 million of finance annually. At that point of time, we started thinking, okay, so with this amount of crop receipt issues on the balance sheets of creditors, we want to work on securitization. But at the time, Russians were standing at the border and hitting the drums. No one wanted to do that securitization. When the war started, of course, volumes dropped down significantly, but now we are gradually restoring, even in these harsh conditions in which Ukraine is now. Agriculture remains the key driver in the economy, and we still have 200 million of finance annually, roughly. So by today, this instrument catalyzed almost $2.4 billion of US dollars of finance to SME farmers in Ukraine, which I believe is a very significant result, with the average amount of roughly 200,000 of US dollars of finance per each transaction. So this instrument created a sort of ecosystem and allowed to create some business models. The most common business model is input suppliers, which provide necessary agricultural input to farmers, whether it's seeds, fuel, fertilizers, and crop protection. So crop receipt is a security, and it can be both financial and commodity, which is securing the trade credit, right? This trade credit is in the form of supply contract. So the second popular model is with financial institutions. So banks also provide loans using future crop as collateral. And in this case, they mostly prefer, of course, using financial crop receipts because they want to end up with money, not with the corn in the branch, right? So then the third model is commodity crop receipts with forward contracts, and it is used by predominantly trading houses and processors. And we also work with the central bank to enable cross-border transactions. And with that, we enabled some loans from non-resident to Ukrainian agriculture. So, as I just mentioned, it created sort of an ecosystem. So by enabling future crop as collateral, now farmers can secure better inputs, increase their yields, increase profitability, secure necessary cash, whether it's working capital or capital expenditures, access new markets
or grow new crops. And with that, the overall liquidity in the sector is being increased, and we also can use some price hedging mechanisms to decrease the risk for creditors. So with AIIFL, we worked together on creating the knowledge guide, which we believe can be a step toward harmonization of legal standards for the benefit of other states which are willing to also introduce these instruments. And we are, as I say, exporting our success now to other jurisdictions. So we are working on the legislation in 5 new countries, in Azerbaijan, Georgia, Albania, Kosovo, but also in Peru. So we are kind of re-exporting our experience back to Latin America. But this crop seed finance knowledge guide, we believe, would help policymakers to shape their legal and regulatory framework in the country for enabling the use of crop seeds, and become a technical foundation for future legal harmonization. So, as I said, to help other states to introduce crop seeds in their countries. And you can use QR code to download these crop seeds. And as Marek just announced, we will be holding a joint webinar on January 20th, and we'll be happy for you if you can join that. And before that, it would be useful for you to read the knowledge guide. So, and just to finalize my presentation, I would summarize the key findings, or you can put /issues that we conclude as a result of our research reflected in the knowledge guide, that we should focus on the legal classification of crop seeds because they can be in various forms. Now in Ukraine, we introduced a new instrument. Crop seeds is still a proxy, but now it's a digital tradable security, which is called a Graham note, and it has a link to capital markets, so you can trade it. And it's fully digital, so with a tax code, a farmer can create easily an electronic cabinet and issue it. So, and this is a, kind of a trade-off. You have to decide whether you want to start with a paper-based to create the foundation, or you want to be an advanced implementer and start straight ahead with the digital security. So this is one. Another issue that we faced with was how to treat future crops, whether it's movable or immovable assets. And even in these jurisdictions that we are working on, for example, in Georgia, it's treated as a movable assets. In Ukraine, it is movable assets. So different models. So you have to really understand the classification. And registers. We also mentioned about registers. Of course, it's better to embed this instrument into existing infrastructure with some tweaks. And it's less costly, of course. But in our case, we had to create a completely new register. But now you can see all the issued crop receipts. So this is exactly when the receivable appears, when it is in the register. So this is a precondition. You can trade it over the counter. You can see the status if it's already under enforcement. And one important thing to notice that there is extrajudicial enforcement, which is working. So even in the worst year in Ukraine in 2022, the level of NPLs was 4%. 4% future crop is collateral. Can you imagine? And there is a 50% recovery rate even after that. So, and the last but not least, how you treat this electronic crop receipt again. So do you want to start with the digital security, or you want to start with electronic form? So there should be certain conditions that you want to envisage. So please join us and at our webinar on January 20th, and we'll be happy to address all questions that you might have. And thank you for your attention.
Well, thank you very much, Kirill, for introducing the audience to this new financing product of crop receipts. And you will recall that during the development of the guide, we had many discussions as to whether we could draw some analogies from the law of warehouse receipts. What is the nature of a crop receipt? Is it similar to warehouse receipt? Is it something completely different? What should be the degree of negotiability or transferability? Is it more similar to a bill of exchange or negotiable instrument or to a warehouse receipt? So we have taken into account a lot of lessons we have learned from the law of warehouse receipts, which brings us to the third presentation on the panel that will deal with some aspects of the law of warehouse receipts in the context of China. Lucy, the floor is yours. Thank you.
Thank you. Priorly, I submit my PPT, but after my 2 days learning, I want to focus on warehouse receipts finance in China, and I have already got the permission of moderator. So the situation in China is like this. Chinese banks have not been with commodity finance for a decade because of the large scale fraud in the past and a huge amount of bad law, have accumulated. So like Qingdao port fraud scandal. And even now, banks want to do some law over commodity. They like goods itself rather warehouse receipt for evidencing goods. There are two kind of reasons. First, when using warehouse receipts, banks still need to monitor goods to prevent non-reception issuance and over-issuance. And secondly, actually in China, using goods as collateral is more efficient than use warehouse receipt. Because in China, to negotiate a warehouse receipt, you need 3 steps: to endorse, to have warehouse sign and to deliver, while to create a pledge over warehousing goods, the only thing to do is to have the pledger to send an instruction to the warehouse. It's rather simple. So less to do means less operation risk. For example, in China, there's a cotton exchange. They use warehouse receipt. They have to wait the warehouse to sign to sign or stamp on the digital warehouse, so it becomes less efficient. So, but in Chinese market, we still need warehouse receipts somewhat, and so there are some kind of warehouse receipt pledge. They are mainly from 3 aspects. First, to deliver under future exchange. We call this kind of warehouse receipt standard warehouse receipts, since the commodity are fungible and they are commingled with the same quality goods in the warehouse. And the second is from the huge spot commodity exchange. They prefer warehouse receipt to goods because it's easier for their operation. And the third is just like what Ms. Xi Jing said, the applying of NCD. Although warehouse receipt is not included in NCD, but it may be someday later. So these are the commercial requirements for warehouse receipt pledge, although the slice is very, very limited. And from the points of banks, they come back to warehouse receipt, have their expectation. Their hopes are to reduce their due diligence in verifying the pledger's authority if they are the real owner of these goods. In goods financing, Chinese courts always held that possession of goods is not sufficient to presume the possessor is the owner of these goods. So you need to check more with their contracts and also some transport documents. So it's very hard for banks to check with these documents. Then come to with warehouse receipts. Banks think this is a document of title, so the holder should be the owner. It's be the owner of the receipts, and also the goods be the owner of the goods it covered. So they could have less drop in due diligence. But so let's come to my legal issues in this regards. I have 3 legal issues I want to learn from all of our experts. So the first one is, can banks rely on the holder's name on warehouse receipts as the owner of the goods? I think it depends, because first of all, if the holder is the initial holder, because in China, a warehouse receipt is issued always to the depositor, not to any named people or to a bearer. So in that case, the initial holder could be an agent, and in commodity transaction, an agent is commonly used, and then bank should be aware of this. So in that case, we cannot see the initial holder of a warehouse receipt is necessarily be the owner of the goods. So in that case, I don't think they can trust a warehouse receipt. Of course, for the subsequent holders, they acquire a warehouse with value. Yes, I think banks could rely on the holder's authority to dispose of it. The matter is, in current finance or warehouse receipt, they are concentrated on the depositors. So the initial holder of warehouse, not the subsequent holders, are the debtor and the pledgers. So the function of a warehouse has not been fully played. This is my first question about this. So what's the general practice in other jurisdictions? So the second issue I want to discuss is what constitutes control over warehouse receipts. Because presently in China, those pledgeable warehouse receipts are all digital ones. So there's a problem when we pledge all 8, what is control? There are different models in China. Typically, there are 2. First is platforms promise to control, and they control by contracting the warehouse. For example, I have a client. It's a new established company. Its name is Shanghai Commodity Warehouse Registration Corporation. They do 2 things to help banks to boost warehouse finance. First, they register warehouse pledges, but they are not the authorized registry to do security perfection. So their registration legally is not a perfection. And secondly, they promise to control electronic warehouses. But the problem is a warehouse receipt is not issued on their IT system. It is issued based on the warehouse own IT system. So they only have contract that bind the warehouse, not to breach their contract and to have their warehouse receipt controlled by the platform. So if the warehouses breach their contractual duty, such as retreat or destroy those digital warehouse receipts, the control is void. So the platform is risky, and indeed, actually, they are offering their credit to the warehouse. But that is not my concern. My legal question is, in such contractual control, is it a valid control to attach a pledge over goods? So then there's another further question I want to raise. If a control proposal is with flaw and the receipts are luckily still there, so will the pledge or a warehouse receipt valid from the very beginning of the so-called control, or when the control, when the warehouse receipt is not there, it's now invalid. So because in very similar goods collateral case in China, the court said when a CMA cannot really control the goods with only 2 people safeguarding a warehouse that is rented from the pledger, which means the management plan is defective for control, then those losing goods, of course, is not collateral for a pledge anymore. So the question is these goods still in the warehouse, and could they be determined that they are attached with pledge from the beginning? They are in the house, in the warehouse, or they are not collateral anymore because the managing plan is flawed, so it is invalid at all. So that is a problem. And there another kind of control, that is IT control. Some IT background CMAs are offering IT system to control the warehouse. They will ask the warehouse to issue warehouse receipt based on the IT system they offered. So this could stop overissuance. And I have a client, they have a very sufficient control measures. First of all, they have a very good IT system, and also they have data from ministry, transport ministry, so they can match the data and the warehouse received very good. But it seems a flawless control. But in real society, some cases still happen. It's a real case in China. Shanghai Future Exchange have their warehouse to seal warehouse receipt with their system, and a warehouse use it to issue the standard warehouse receipt, but he colluded with the depositor and used another set of system to issue many warehouse receipts. So the problem is, in this case, can we see the CMA still control the warehouse receipt? So I think there are three layers of problems: IT control, contractual control, and even no substantial control over goods, but to use their influence, such as huge platform, to control the warehouse conduct intention, not to the goods itself. So in this case, how can we determine the control? Has the control been established? Or when the warehouse go wrong, the pledge could be denied, or from the beginning, this kind of model is not valid. So this is the second question I have faced in reality. And the third problem is the method of commingled storage. In China, commodity are always mixed together in warehouse. That's the real practice. But Chinese lawmakers are blind on this practice, and no rule, no guidance in this regard so far. So as Professor Lee said yesterday, the silence of law would cause cost, and we have burdened this cost. Then when using this warehouse receipt to evidence these commingled fungible goods to pledge, it would be very complex. because in we can comparing it with fungible goods that is fluid in warehouse. They move in and move out. If we taking those goods as collateral, in general, the opinion is okay. In general, the general opinion is the pledge has been attached to specific goods again and again. So the perfection time has been pushed back accordingly. So if a warehouse receipt has to be reissued again and again, so would the perfection date, perfection timing also be postponed? So that's a real problem in China, but there's no rules in this regard. So that's what I have found in Chinese market, this problem, and there's no addressing, no answer from the lawmakers. So if I can learn from our experts, that's my great honor. Thank you.
Thank you, Lucy, for that wonderful presentation that illustrated the practical issues that even very developed markets in terms of warehousing face, both in terms of designing the law and structuring the transactions. As for your legal questions, I will volunteer Henry to answer some of them during the lunch break, as he's one of the architects of UCC Article 7 that has become the global model for warehousing seize laws. So with that, Henry, having heard from the previous speakers, what do you suggest we do going forward? Thank you.
Is it turned on? Yeah. There's a couple of things we can do, but speaking from the UNIDROIT perspective, I'd like to spend first couple of minutes explaining how we got where we are and why we are where we are. We talk about agricultural development, which is very important, but it all leads to food security. At the end of the day, it's feeding people, and the world simply needs to produce more food. And we know that. We've got 2.4 billion people who go to bed every night with not enough food to eat. And how can we resolve that? Well, there are a lot of problems that can be resolved. But of course, the big issue here in a room like this is, okay, well, that's all well and good. And I mean, we understand the state of the world. But what does it have to do with private international law? And what does it have to do with an organization like UNIDROIT? Back in 2011, the then Secretary General of UNIDROIT came up with an idea that we might be able to connect the expertise of UNIDROIT and private international law to this notion of food security. And we had a colloquium back in 2011, big colloquium, and started formulating some ideas. And so the current sort of large program in agricultural development in UNIDROIT goes back to 2011 to that, because this has been very much a part of the sort of DNA of UNIDROIT since then. And so I think that's important to keep in mind. At the initial stage of this broader policy concept, there were three sort of sub-projects that were proposed, and two that have been completed and third almost completed. I'll discuss those, but they're chunks of the pieces, because the project I want to talk about that's going to begin soon, the agricultural supply chain project, is an attempt not only to take all the pieces that have sort of emerged over the last 15 or maybe 20 years, when you want to add the MAC protocol to it, and say, well, we've got some nice pieces here, but we need to put the pieces together, show how they fit together, and then fill in the gaps, because we've never dealt with the full supply chain. So that's where I think we're going, the big we. But the first project, as many of you know, that UNIDROIT undertook was the contract farming guide. The contract farming is
in its essence, agreements between a farmer, a producer, be it agriculture, be it animals, food or whatnot, and a buyer who says, I will agree to supply you the inputs. I'll give you the pigs, I'll give you the chicken, I'll give you the seeds, I'll give you the technological know-how, and then I buy the crop from you. And what that does is set a system so that we have so the farmers, the producers, have some sort of guarantee that if they produce something, they have a buyer. And contract farming is not a new concept. It's, for example, in the United States, it goes back 160 years. The concept, but it is new and developing in a lot of countries, and so that's what the contract farming guide does. And that was the first project. Well, it's all well and good to talk about. We have farmers here, but and I think probably, if you look at the pieces, one of the most difficult problems is, well, I'd love to be a farmer, but I don't have any land. So that was the second problem. So we have the legal guide on agricultural land investment contracts that deal with the notion of contracts to buy, to finance, to create an atmosphere where the farmers will have tenure of land, these sort of things. That's part of the pieces. To me, this is one of the most difficult parts of the entire process, and that is, we know that in a lot of countries, a lot of developing countries, land tenure is a problem. People have been farming in those chunks of land for generations, and nobody recognizes the type of land tenure, the type of land ownership that they need. So that's sort of the second part. And that project, which I think is very important, the Legal Guide to Agricultural Land Investment Contracts, that was the second project. And the third is one that is coming to fruition. It's being worked on, but that's the project on collaborative legal structures for agricultural enterprises. With the conceptual model that I had in my head, and I suspect many people working on the project had with contract farming, is I've got a farmer and I got somebody that's going to buy it. Well, that's not the way the world works necessarily. You don't necessarily have a farmer. You may have a cooperative or a different structure of who this producer is going to be. And that's what this third guide is designed for. And I should point out, all three of these projects were done jointly with other organizations, with IIFL, with FAO, organizations that have long experience in dealing with the type of agricultural questions that these deal with. So that collaborative part, I think, is very important is for what UNIDROIT has done and what they'll do in the future. So those are the three projects that were immediately envisioned as something that can be done. This third one will soon to be completed. But I do want to mention a couple of little side projects that fit into the overall project. And one is, of course, the warehouse receipts project that was done jointly with UNCITRAL. And I think the model on warehouse receipts is very important. That idea also popped up with UNIDROIT back in 2011 at the seminar. And it's interesting because I remember giving a paper on warehouse receipts. This is a great financing tool, and this, that, and the other. And at that conference, there were the private international law people, and they're the development people, and it's very difficult to communicate because people live in different worlds. But I remember being chastised and saying, this is a very clever idea, professor. And whenever you're being called professor, you know what's coming next. And he said, the warehouse receipts for financing? Financing what? Who's going to build the warehouses? And how are you going to get electricity to the warehouse so the The grain and everything stored is not destroyed. Oh, by the way, you need roads to and from the warehouse and get you to the port and this, that, and the other. And who's going to develop all of that? And I thought, well, those are very good questions. And they are very good questions. And they're still very good questions. But part of the answer has to be, I believe, yes, somebody's got to finance the warehouses. But we need a legal structure to facilitate the type of trade and the type of financing once the facilities are there. But I do keep in mind that a lot of these projects we're talking about rely on something external, some infrastructure that has to be there. Another project that I think is important before I talk about the new income, and that's the MAC protocol. Because the MAC protocol, as Will went over, is I think very important part of the framework of agricultural development. Certainly, mining and construction equipment is very important, but so is agricultural equipment. And when we look at the aircraft protocol and we look at a country that ratifies Cape Town and the aircraft protocol and finds out that they can buy airplanes at a 3% discount, and that's than what they otherwise could do. And that's a lot of money when you're talking about multi-million-dollar aircraft. That's a huge financing. So when we talk about getting agricultural equipment, when we're talking about getting tractors into developing agricultural economies, if we could get that price down significantly, there's going to be more tractors. And if there's more tractors, there's going to be more food. And if there's going to be more food, then we're getting where we want to get to. So I think both the MAC protocol and the warehouse receipts project are very important in this whole panoply of agriculture development and food security, which then brings me to the new project. And that's Legal Guide to Agricultural Supply Chain Financing. And that title that I just gave you is the one that I just made up. But that's what the guide will be. That's conceptually the idea. And one of the things, particularly in this body right here and now, we understand the importance of finance and secured finance. And secured finance equals credit. And if you believe, and if you don't believe this, you have no business being in this room, that credit is a social good, then you appreciate that if we can bring in the concept of credit as a whole and secured credit into agricultural development, we're going to go back to where I think we need to be talking about, and that is more food. So the first thing to appreciate, and it's a glaring gap, intentional gap, because it was never intended to be handled, but in the contract farming guide. And the contract farming guide says, I've got a farmer here, or somebody's going to raise chickens. And because the way it works in America is the producer comes and gives the farmer the chickens and finances the feed. And then when the chickens get big and fat, off they go. Same thing with the pigs. Same thing with the cotton. And by the way, we have electronic cotton warehouse receipts in the United States, period. And they work well. So we do know how to massage that problem that you mentioned. But anyway, the gap that is there is 0.1 to 0.2, but that's not good enough, because we got to get the food or the produce from the producer to the contractor to the buyer, all the way up to the chain to the supermarket, right? We got to get it to the supermarket, or somehow we got to get it in somebody's plate so that they can eat. And so that entire supply chain is what will be covered in this new guide. And there's a lot of aspects to it. Certainly there's the security interest aspects, but there are also regulations that flow through the whole thing. There's standards you know, if I go in and decide that I want to pay 3 times as much for my bananas because they're organically grown or whatever it is that they guarantee about my bananas so that I can pay triple the cost. And joking aside, that agreement that this product has certain qualities, that agreement has to go all the way back to the farmer. And how do we do that? How do we do that? Because that's not a contract. That's a series of contracts, and that's a series of contracts that have various regulatory or other trade usages embedded in it. How do we get there? So that's what we're talking. So broadly, and this is broadly, and I'll get to the more specifics, broadly what this guide should cover is credit and finance transactions typical in agriculture, because we're not talking about credit finance in general. We're talking about agricultural credit and finance. What are the existing and emerging instruments that already exist? Because you don't need to reinvent the wheel if you have functioning wheels. You may have a few wheels missing, you invent those, but what's already there? What are the existing standards? Because as with any product, certainly any product coming out of UNIDROIT, it's going to emphasize best standards, best practices. But before, am I being told how many minutes? 2. Okay. So before I can understand or study best practices, I need to know what existing practices are. So that has to be looked at. And then what are the gaps? What haven't been covered in this supply chain? Now, the specifics. Pre-harvest finance. I need money to do what it is I'm going to do as a farmer. I need finance. So it's got to cover pre-finance. Forward contracts. Can you guarantee me that if I produce this, you will pay me X amount down the road? Because if I have that, if I have a promise of future payment, I've got something that I can use for credit that works through the whole thing. Contract farming fits within that model with a little extras and all. Secured agricultural production loans. Most of what we're talking about, forward contracts, contract farming, these are contracts to buy the goods. But we don't necessarily need in the supply chain an agreement to buy the goods. We might just be taking security interest in the goods during the supply chain for financing. In the same way that I might take a security interest as opposed to buying your receivables. So we're going to look at that. Crop receipts financing. We just heard an excellent presentation on that by Kirlo. On that is a developing type of agricultural finance. And that, of course, is something that needs to be covered. Post-harvest financing. I got these things. What do I do with them? How do I market them? How do I get them to market? Those sort of things. So that's sort of the last end of this. You finance it, you know, the transportation, the whole thing. And so those are the major areas that I believe the guide has to cover. I could get into the details, but if I try to do that, Jay's going to tell me that I'm out of time, which I appreciate that I am out of time. So anyway, that's an overview of what UNIDROIT has done and where I think UNIDROIT is going to go with a project that, to me, is going to be extremely important as we move forward and for agricultural development. Anyway, thank you very much.
Well, thank you, Henry, for that excellent presentation summarizing the key issues that we face today and how to address food insecurity. And thanks to all the panelists for their excellent contributions. I'm going to turn it over to Jay to transition us to the next session. Thank you very much.
So without further ado, I would like to introduce my boss, Anna, for some concluding remarks about this conference. Anna.
Thank you very much, Jay, and thank you to all of you for bearing with us a little while longer. I have been particularly interested by the discussions you've held this morning. Find them very challenging, lots of great ideas, lots of great inputs that resonate very well with the work that we do. So thanks for indulging us for this these few concluding words. I would like to start out by saying how honored and pleased we are to give these concluding remarks for the 8th Conference on International Coordination of Secure Transaction Reform that is hosted by the University of Hong Kong Law School and the AIIFL, Asian Institute of International Finance Law, and of course, organized jointly by our partners in the coordination network. It's a great pleasure to be here in Hong Kong, a vibrant center of international finance, if any, in the heart of Asia. And I realize that it's also a time of sorrow in Hong Kong after the fires that have ravaged buildings and claimed so many victims in the territory. So I'd like to offer our heartfelt condolences to the families of the victims and the firefighters that have lost their lives. But allow me to turn to the more joyful and festive words I would like to say by thanking our hosts here at the University of Hong Kong, Dean Howling Fu, that I had the pleasure to meet this morning, Professor Giuliano Castellano, our convener, a solid member of the network and of the secure transactions groupies of UNCITRAL's work, and also always gracing us with his presence and his views each time we convene a meeting, an expert meeting, a colloquium, or a commission session. So thank you for that. I'd like also to thank his colleague Candy Yip and all the speakers from Hong Kong, from the region, and from all over the world for sharing their knowledge and contributing to what I understand has generated some very interesting discussions, sharing of information, and also practical experiences. And I think that's what really marks this, this network, and each gathering we have is that we're talking about very concrete matters. It's all about the law, but the law applied to very concrete day-to-day problems and issues of our MSMEs and of our agriculture stakeholders, I understand from UNIDROIT. And therefore, I'm very grateful for the continued work in this area. We value the coordination network for secure transactions, especially because beyond coordinating our promotional and technical assistance efforts, it also gives a lot of food for thought and ideas for future developments and for work together in providing finance for trade and development. During the discussions, reference was made, of course, to a number of UNCITRAL texts, not only in the area of secure transactions, because it goes much further than that. And there are a lot of components of UNCITRAL's framework that are relevant to the discussions nowadays. And I'm very pleased to see how much interrelation and how much cross-fertilization there is between different streams of work of UNCITRAL, particularly when looking at the digital transformation that international trade and subsequently, of course, international trade law is going through nowadays. So beyond the secure transactions framework that has been developed over the years by UNCITRAL, we also heard mention of the model on electronic commerce, the model on warehouse receipts. I was very happy to hear about its developments and also the perspective in China. Thank you very much for that. The model on automated contracting, which is really at the heart of the digital transformation, and the NCDs convention. It was nice to see the NCDs convention, which is typically a transport document, all about transport documents, fitting so neatly into the discussion. So thank you for building it in. We have great expectations for this new convention that will be adopted by the General Assembly in a couple of days. And it's really interesting to see how Professor Gabriel said, how it all comes together. We are going full force ahead to accompany this digital transformation of international trade, but we're not forgetting the promotion of the program on MSMEs that has also been a way of bridging the different silos of international trade law, and the most recent legislative guide on access to finance. Most recently, UNCITRAL's work has been flagged in the outcome document of the Seville Finance for Development Conference, which is the UN's roadmap for finance for sustainable developments in the years to come. And so we were very pleased to see, because that's not something you lobby for. It's generally, it comes because it is seen as relevant by the member states that agree on this outcome document. So we were very pleased and very honored to see our work recognized. We look forward to continuing to work with all the institutions gathered here today in Hong Kong. We already and heartfully invite you all to join the forthcoming colloquium that is being organized by the UNCITRAL Commission in New York in February 2026 that Jay and Monica are putting together, where we will have a secure transactions in the 21st century dive in. And we also look forward to the session of the Commission in New York in June 2026, where the output of this colloquium will be discussed and we hope moved one step forward. So once again, thank you very much. Thank you to Hong Kong University. Thank you to the network partners for joining here, joining forces and continuing to work together for the greater good. Thank you.
Thank you. Just to add on the colloquium that Anna mentioned, it will be not only about secure transactions, but the latter part will be about digital platforms, since Teresa is here. This actually is a kind of where we can actually discuss both topics in one. So with that, maybe Nacho, any concluding remarks?
Thanks very much, Jay. Thank you. I will be very, very brief. This has been, in my opinion, a truly excellent conference and a great new edition of the partnership of the coordination group. Particularly insightful, I believe, and helpful for us have been the presentations, which have provided us with a very comparative approach to secure transactions and how they're being implemented with different perspectives. We've heard about many examples in Asia, with Asia Pacific. We've heard about many examples in other parts of the world, including Africa, Europe, even Latin American examples from the real experts that are working on the ground. And we've done that both concerning the developments of the existing instruments and the digital perspective of it, or the digital side of that, which is the more modern part, where the different organizations are trying to take instruments which at their core have been around, some of them for more than 100 years, to a new dimension, with new potential to really be very helpful. So that has been very useful, has been great for us, especially because it tells us the status of the situation, where we are at this very moment, but also where we can improve. And a number of elements have been identified to move forward and to improve the instruments that we have. We've enjoyed also the new side of looking at having a close look at the close-up at intellectual property and related type of assets for secure transactions. And we thought that was a type of insight which we're not so used to looking at. This is, of course, a classic UNCITRAL topic. It has even a part of the legal guide on that. But for other organizations, it's newer and provides very interesting insights. The possibility of looking at enforcement and dwelling on the digital part of enforcement and also of other elements concerning when things go wrong in secure transactions was also really enlightening. So thanks a lot. I think we can say, at least in my opinion, this is one of the best conferences that we've had of the Secure Transactions Coordination Group, in terms especially of content, but also of form, of course, in this lovely place. For that, we would very much like to thank Hong Kong University and the Institute and Giuliano Castellano, as well as UNCITRAL as this year's convener, especially Monica Canafoya and Jason Lee for the hard, excellent work. Thank you so much for that. It's always great to work with you. And I'll finish just saying that I join Anna Joubin-Bret in showing my and our institutional regret and sadness for the sad occasion of what happened here yesterday in Hong Kong. Thank you for your patience.
Thank you, Ignacio. So Murat.
Thank you, Jay. Maybe I should start on a quick personal note, just to say how glad I was really to make it to Hong Kong. I wasn't sure until the last minute I'll be able to make it. It was fantastic to come and reconnect actually with some of the colleagues that I haven't seen for some time. In the World Bank group and in IFC, we really value this network, this conference, because we think it's pretty important for us to occasionally, at least once a year, to take a stock of where we are, and then think of some new topics and understand our challenges, and most importantly, exchange some of the ideas how we can improve this practice going forward. And I was particularly happy to see this conference focusing so much on digital aspects, because there's a lot going on, especially in the last few years. It is pretty clear, at least to me, that all asset-based and supply chain finance programs and all types of products that we talked about today, whether it's programs that's going to be based on intellectual properties, based on warehouse receipts, supply chain finance, trade finance programs, it all has to sit on the digital rails. Again, in the previous panel, I was talking about our experience working with financial institutions, and every single one of them these days only asked about the platforms and how can we automate, scale up, monitor, de-risk our practices through technologies. This really becomes indispensable right now. So I would very much like to see this group continuing its focus on digitization. Just to give a quick example, and that's to Teresa's and Megumi's panel yesterday on digital assets. So IFC is coming up with this idea to create the digital invoice. So basically, when a factor finances against an invoice, you have to confirm certain things, right? You need to have a number of checks. Let's say identity of the supplier has been confirmed, the buyer accepted the invoice, there's no double invoicing, et cetera, et cetera. So what we're trying to do is take these checks and turn them into the cryptographic proofs that then generate a kind of a token, if you will, our digital invoice, that using the zero knowledge proofs strips out this invoice from all the from all the personal information, so that it then can be bundled up into portfolios that investors can easily invest on. They will not see underlying details of the invoice, but they will see a token that confirms to them unequivocally that these proofs have been embedded and incorporated. So this can become a kind of a, an asset that investors like IFC, for example, can use to provide financing the needed to this factoring company. So we're not talking about on lending to suppliers, we're talking about attracting funding for factors themselves, especially some smaller fintech maybe companies or smaller factoring companies that actually need liquidity to provide operations. So that's we
we're just discussing the technical aspects of it. We haven't looked at the legal implications. There will obviously be legal implications along the lines of what is it and how do you perfect, do you control, do you possess? It's something new that we try to come up with. And this is just one initiative like this. There are many things going on in the space that obviously deserves the attention. Two more points I think that will be very good for us to table for our next conference is again, go back to the sustainability angle. We had the session, I think, last year in Istanbul, talking about fairly briefly, but again, there are more things happening in the space, particularly for trade and supply chain finance, and how you would sort of create the sort of green value chains and what sort of legal underpinnings and taxonomy is needed to promote these types of arrangements with the climate space. And another topic that we haven't talked a lot about, and that is alternative data. All asset-based finance programs are essentially based on data. And if you can build predictive models based on information that you get from non-traditional sources, like from utility companies, there's a lot of transactional data that is flowing. And through the supply chain finance and asset-based finance programs themselves, there's quite a lot of data that can be utilized and that will have predictive value that financial institutions can use and utilize to lend against. So these intersections between asset-based finance and credit scoring is something that will be very interesting for us to take a look at. And just a quick note for the network, IFC is planning to organize a series of regional conferences on asset-based finance and credit scoring programs. One planned in the Middle East in December, jointly with the United Arab Emirates Central Bank. We don't have the dates yet, but once we finalize all the details, we'll be in touch with the network to see, if there will be interest to participate in this event. There'll probably be other regional conferences like that, so it will be good for us to interact on that. So yes, so huge thanks to the University of Hong Kong, Faculty of Law, Giuliano, UNCITRAL for preparing this excellent agenda, and I very much look forward to the next one. Thank you.
Last but not least, Bob.
Is it working? Yeah, there we go. The voice of God. Hey, thank you, Jay. And thank you to all our hosts. This has been amazing in terms of content and facilities. This is the 8th conference, and I've been to all 8. And, this is the best one. I mean, if you look out that window, look at those mountains and the sea, it's just incredible. So thank you to HKU and Giuliano and Jay and Monica and everyone for putting this together. The panels were really great. They covered all the key topics and the discussions were deep, and the one-on-ones with all of you is what really makes this special. So what I've heard over the past day and a half as the representative from ILI, and Mark wishes he could be here in person, but we have this thing called American Thanksgiving. So I heard 3 kind of big things. One was we're getting back to basics. So why are we all here? Why are we talking about this stuff? It's because we're trying to make the world safer for modern secure transactions and really getting the credit to MSMEs and underserved sectors. And so, yes, having the right law will make big corporate transactions work better, and JP Morgan will be richer, and the corporate lawyers will be happier. But really, our success is going to be looking at, have we helped small businesses grow? And so how do we measure this? One of the ways is to understand the rollout of the products we talked about, like factoring, supply chain finance, and eventually full asset-based lending with revolving lines of credit. We heard many examples from people on this panel about certain countries, how it appears things are going really well, but once you dig further, it really hasn't grown as much as we thought. And so more work was needed that was done to make it more real for people on the ground. Measurements are important. Another idea is the update of really reviewing what individual countries are doing kind of on a regional basis in the context of secure transaction reform. As we know, as we heard from the UNCITRAL and UNIDROIT folks, there's a whole bunch of new texts, new instruments, the digital asset principles, model on factory, model on warehouse receipts, Milot have come out in the past few years. But have we really looked at now with those new texts, those new tools, how can we grow individual countries' secure transaction reform in a regional basis? So the other point that I heard was, how do we make the rest of the world out there care about secure transaction reform? The way I make my friends fall asleep is say secure transaction reform. But if I say food security, everyone is interested, like Henry said. And so phrasing this, selling this, describing this as food security or agricultural finance or access to finance to women or gender finance, those are the ways that we get people interested, and we need to do more of that. Words matter. The second big idea is we've heard the word digital a lot, and I see it hitting really two key ways. One is digitalization, so taking the paper stuff and making that electronic. So electronic signatures, electronic invoices, those things really matter, and making the law work with those new digital forms is incredibly key. And I think that's where we help the MSMEs. Then we get to the other digital, the digital assets, the digital CBDCs, central bank digital currencies, stable coins, cryptocurrencies, tokenized deposits. Those things will be helpful, and those things are coming. But is a woman farmer in Nigeria going to really care if a smart contract is going to work legally? I'm not sure, but I hope so. But if all we do is make large crypto holders and JP Morgan happier, that works for me. But that's value of a different nature than helping SMEs. And then finally, the final point I heard was we're transitioning from law on the books to law in action. So there's a lot of need for capacity building out there. And, that's with financial institutions. The law is great, the law works, but the financial institutions aren't doing it. So we need to do capacity building in the actual banks, in the fintechs, in the central banks. We need to do more capacity building in enforcement, whether it's judicial and the judiciary, the judges, or extrajudicial, or is it with the regulators and regulatory capacity? So nudging the MFIs and having them nudge the central bank is incredibly important. And so the bottom line is that there's still much more work ahead of us. And I leave this session today really excited about doing that work. Jay, back to you.
Thank you, Bob. I think that concludes the session. I just wanted to have one word, which is that it is the joint network for coordinating and supporting secure transactions reform. In that context, the joint network members are in the business of promoting international standards in secure transactions and promoting access to credit. In that sense, we're kind of an influencer, and we need likes and followers in order to actually have these international standards implemented. And this is what we're doing, but it's also not enough for us to be liking each other and following each other. We need to actually expand further. And actually, this goes back to what Bob was saying. We need to actually hit some of the hot words like digital finance, IP finance, startup finance, farmer finance, all of these things. But then once we get the interest of those through these words, it actually gets back to our square number one, which is the secure transactions basic framework. And this is probably what this event is about. We need to actually go out to the world to actually get their interest, to get them in, and then kind of see where we are, and then we'll finally have them interested. I think this is what we are actually here for, and we hope to continue this conference onwards so that we have more followers and more likes to come.